especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How period does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more can we see? Because he's the guy.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. We are minutes away, moments away maybe, just moments away from being back in court with what should be the closing arguments in the case against Zachary Hughes. This is a wild one. We're in South Carolina for this one, by the way. South Carolina versus Zachary Hughes. This could be the final day. Depends how long the jury wants to deliberate, how long closing arguments are going to take. If there's any legal discussions or arguments that have to take place outside the presence of the jury that could slow us down in some way. We think we have all the jury instructions squared away, that those are done, but we'll see. Welcome, one and all. See, I watched it again, says Ivy Berlin. Oh, wait, okay. I watched it again and I stumbled over Josh saying he was asked if there was, let's say, if he would have alive or no proof presented at any time. Yeah. Leonie, congratulations. Let me put you on chat first, on screen. You were first in chat this afternoon. I'm not sure if you know this, but that's both a good thing and a bad thing. When you're the first person in chat, you've sort of played all your cards and shown everyone that you're very eager to be here. You broke the stillness of the silence in the chat room, and by chatting first, you let everything else happen. So basically, since everything is your fault in chat, we're just going to hold you accountable and make you the owner of the internet for the afternoon. You're responsible for everything IP related worldwide. If it connects to the internet in some way and there's a problem, you should be hearing about it. So we'll go ahead and just pass that number out to all the appropriate help support centers, and they'll be contacting you. So, Leonie, congratulations on being first in chat. It's awesome. It's going to be great. All right, we are waiting to come back, and waiting and watching with bated breath to see what happens. Defense attorney will need to tread carefully during closing. I think he's going to stick to his open. He's going to stick to that. There was no malice. This was not a depraved heart. He's gonna play that banjo like his life or his client's life depends on it, because it nearly does. Hoping for a lesser included, or if there are no lesser included, it's hoping for not guilty. But not guilty, I think, would be jury nullification, especially when you have the defendant who says, "I did it. I did in fact do what I am charged with, but I had a good reason." Good reason is not good enough in this case. I think in South Carolina, it does not allow for that under the law. Maybe the law needs to be changed. That's a different argument. We are hearing that the delay is going to be reduced for closing arguments. That's why we're back a little bit early in case we get that we get the benefit of that. So, all right. Tequila Mockingbird says, I'm settled in. I'm ready to go. Wonderful. All right. Is dragging her by her ankles malice? No. I think the state just wanted to ask a question to say we did cross-examine him, and in the question was the insinuation or admitting that you did in fact commit this crime, and we've already got everything we need. You don't need to hear your drivel, whatever that is. All right. Let's see. Welcome. Everyone, please take a seat. Let's see. Do you think, says Cody, do you think the delay was so they could get the jump on the dad, or was the judge just annoyed at something on the coverage? No, I think I think the judge was not annoyed with anything on the coverage. It's just that some courtrooms have this. I've been in courtrooms where we've live streamed from the jury pool, and we had that order. It has to be on a delay. Sometimes they tell us how long the delay is, and sometimes they don't. I interpret it as a very narrow delay. When the court realized what I interpreted as a delay, they said, we'd like a longer delay than that. I'm like, well, then tell me. So it's just one of the things that judges do. There are some courtrooms that do think that that they can somehow catch something before it goes out live, and they can. The judge can order the media who's covering a trial to not show what just happened. Unfortunately, if they do it live, you don't have that option. You can't go in and cut something out or edit it out. But all right. Case is unreal. The victim was allegedly a horrible person, yes, but criminal justice system should have dealt with her. I agree. Diana Meyer from way up in the sky. So it's from 30,000 feet. Enjoy the view. Thanks for checking in from high above. Have a safe flight. Enjoy the destination wherever it is you are going. All right. What time will we see a feed? Possibly any moment now. Let's check. Oh no. Okay, buckle up, guys. Buckle up. I don't want to spoil it because it looks like there are fireworks. It looks like there are fireworks, and we should be able to see them. So hang tight. Just wait for it. Just wait for it. And I don't even know what to say anymore. Wow. You know, every time when it's got crazier, we're like, wow, I didn't think it could get this wild. It might be getting wilder. Best Nancy, welcome to the gallery. Thank you, Nancy. Thank you, Nancy, for supporting the channel. That means a ton to us as on the channel, both the community as well as individually and myself personally. I thank you for that. Buckled into my 5-point jump harness. That's the way it sort of has to be today. All right. Yeah, do keep the spoilers out of chat. I realize they're. Oh, hang on. There we go. We don't have to wait any longer. Jury's coming in.
Okay. Thank you again for your attentiveness. We are about to begin closing arguments. Stay.
Thank you, Arnett. Please report.
Good afternoon, ladies and gentlemen. This is the moment where myself and the defense have an opportunity to speak to you directly. It's called our closing statement, our closing arguments. All the evidence that you're going to hear in this case, you've already heard it. It's either sitting right here or it's through testimony that you've already heard. And so my goal here is to just talk a little bit about this case with you and sort of explain the state's perspective and how we have proven beyond a reasonable doubt that Zach Hughes did in fact commit the crimes that he's alleged to have committed. And I'm going to go through those crimes a little bit, and we'll talk a little bit about that. And then I'm going to go briefly through the evidence and explain my perspective on those things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial.
Yes.
So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hofreth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you were going to find that Zach Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zach Hughes, we did in fact prove all of that beyond a reasonable doubt. Zach Hughes is a cold-blooded killer. Zach Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we're going to abide by his rulings, you must abide by his instructions. Remember I told you he's the referee, he calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago, then you can probably remember back in last week on Monday, a week ago, and you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind that you will absolutely do that. Now, before Zach Hughes admitted to the murder of Christina Parcell, the state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zach Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believed in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it is undisputed that Zach Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses. She had just returned home from an interview, from her last interview with Vet Tech. Zach Hughes, a person she had never met. She had never met him. Beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind of the charges that you're actually looking at. So the first charge I'm going to explain is the harassment charge. And there's 2 harassment. There's harassment and there's conspiracy to commit harassment. The only difference is that conspiracy requires 2 or more people joining in to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and cause that person, and would cause a reasonable person in his position, to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence, some were just described, because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And to remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. and they enter without consent and are armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zach Hughes went in under a ruse of roses according to his own testimony, but he went in directly with the intent to commit harm, and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart, with the intent to harm somebody. And there's also express malice, meaning it's expressed. It's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation, is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So, before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zach Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So, the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zach Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they had always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Ayden out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes, my daughter's out of the country, I can't see her or talk to her, and she's with her father. Thus, the continuation of this nasty child custody dispute. And then from October to April, Ayden was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormelo. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that have been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day, through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned, not in favor of Christina Parcell. She lost her life as a result. So, what is the relationship between Zach Hughes and John Mello? All right. So, where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Ayden, and Zach played a very likable classical music piece that John Mello and Ayden liked. And that's how they met. So they met that one time. And that was one of the few times that Zach Hughes actually met Ayden Mello. And he talked about, they went on about 4 or 5, maybe 6 occasions where they were hanging out. They got some tacos one night. They saw a museum. But Ayden Mello didn't know Zach Hughes. She didn't know who he was. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's. And that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy. And with him went Ayden. So Zach Hughes never spent any more time with Ayden, what little time he did during that small time, never again. Now, he may have seen her on a FaceTime while he's talking to her dad, or he may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Ayden's back with her mother. She, in May, begins living at Canebrake with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zach Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between two consensual adults engaging in what acts that two consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. Let's make her look like a prostitute and let's send them around to a neighborhood. Well, they sent him to a neighborhood where Brad Post lived. They didn't even send him to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, investigator Sparkman, manipulating these WhatsApps. And then they sent them that way, and then Zach Hughes receives them. He gets them. And he sees an email that was sent to him as well. And this email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. Box. Brad Post. Cigar bar. Where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T. Which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell, and you've got another photo of Christina Parcell back there, which is the same ones that are in here, but there's no URL with Bella Dongion right here. And this is the escort site, and it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website, except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mullen Investigations. John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations, and she received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together, and he wanted to make sure we knew it was her, and so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that. But the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment.
Doesn't.
And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute. But he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work in. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know. He's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012, and of course this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelo's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her, to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years, he would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Carmelo. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Carmelo. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zach Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for what, 3 weeks in June in Italy. So he met him for 5 times between August and October of 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zach Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zach Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zach Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zach Hughes. He murdered Christina Parcell, mother to Ayden, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Cormelo because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, "You have any information about Christina Parcell that I know about? I'd like to know anything about." Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Fields says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Ayden had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zach Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way, so he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So, Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. His custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zach Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near Canebrake and ride his bike in there. And we didn't know, but we know that he knew the schedule of Christina Parcell that day. Because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near Canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zach Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We'd shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zach Hughes proved it. So Donna Gorman sees him, and she says this around 8:15-ish when he goes by. And then he goes to Christina Parcells' house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the mountain house all the way to Canebrake. And you know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. He had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards. And he kills her. So let's see the moments before Christina Parcells is murdered. Zach Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he was. I know he had flowers on him. And he walks in and he surprises Christina Parcells. Points a gun at her and hits her in the head with the gun. And then he stabs, and he begins to stab, and he begins to slash, and he begins to slash, and he begins to stab, and slash. Now think of the force needed to stab someone in the chest, stab them in the back, all over the head. And finally, and through all the fighting, and the stabbing, and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head, she has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected, as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood, with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. But his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. Then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch, or under a chair, right down from her body. Killing her wasn't enough. Shaming her was the goal too. This was not to save Ayden. This was to help John Mello win his custody case. He never told us about the drugs either. Never mentioned those. So then the cover-up. So then, after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So, he first had to cover up the scene. He had to worry about that DNA under her fingers. That DNA is key to this case. He had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there because his phone puts him there around 1:17. He connects to the Wynn Wi-Fi. The Wynns have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wool said it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. Now, I've mentioned Zacchaeus' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely diminished sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words and I'll reference a couple. I wanted to make her death quick and painless. This is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury. Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I'll ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time? Was it quick and painless when he stabbed her the second time?
I'm trying not to count.
How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone-cold-faced way. Told me the answer. Like he was proud of it. He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So if you didn't get caught, you've solved the custody problem. But if I did get caught, then I didn't solve the custody problem, because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done. But he described his sister Grace in great detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you. Maybe he's describing himself. He said, I feel pity for her. He felt pity for Christina Parcell. How was that even possible of a human being? His heart is so mean, so depraved, that he viewed someone he'd never met and discussed the specific details of killing her, treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that. Christina Parcell didn't have to die. Zach Hughes had a million opportunities to not do this. And if he did it to save Ayden, there's a million ways to handle that. Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
May I please report?
Let's make it close. Malice?
I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Ayden Mello's problems. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence. Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent, that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell. But that in and of itself does not make him guilty of murder. That's very important. Okay? The first part of, or Mr. Wilkins had talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach admitted that he killed Christina Parcell, right? Where the dispute is, where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind, that the state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act. Right? That's what they have to do. So the heart of this whole case, Mr. Wilkins can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent, is the mens rea. What have they proven about Zach's intent? All right? Now, let's talk more about what the judge is going to charge on the law and what they have to prove about intent, about the mental side of this. All right? Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing, he sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins, in his opening statement, said, we have to prove the state beyond a reasonable doubt an angry heart, that Zach was mad. That's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derive knowledge about what happened. Right? That is direct evidence. The state has the burden of proof on the mental element, and the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here, to try to establish the burden of the mental side? Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down, stab, 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 slash. Right? Gotta watch. Gotta be careful, right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it. Right? But when we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. Right? Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incised wounds. Superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, in determining how much weight to give to their representations about their conclusions on the circumstantial evidence. Just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In fact, Zach said that he was wearing a hat, or a smaller hat. There is no way that she could have seen Zach Hughes at 8:15. Because by the state's own evidence, with the ring cameras, with investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said. Because she said 8:15, by their own admission, by their own evidence, Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about investigator Sparkman, right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Ayden and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormelo and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormelo. Jake Hofferth asked Ms. Cormelo, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide, and you to decide alone. Prior to October 13th, 2021, did you have a recommendation as to where Ayden Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormelo's answer to that? And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcell gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcell? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Field's affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcell from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that. Right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Hall's in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcell, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other, and let's talk about the elephant in the room. Let's just talk about that Mr. Wilkins discussed. The planning. Right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, and it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed. This is a mother. The person who's charged with caring for your child. Most importantly, the person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, the evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about, this was just interjecting in the custody, just get John custody, get him custody, all right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is, Ayden and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this. And you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. Gotta watch the state, ladies and gentlemen. Lot of in the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? How does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back. When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said, we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen. Okay? The judge will not instruct you that Zach Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zach Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that.
Because it's self-defense.
The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save Ayden Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case. Right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people. Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion,
please do.
The state has brought us here, and they've brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charges they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zach Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child is not a murderer. I would ask that you return a not guilty verdict. Thank you very much.
I don't know if I want to give this attorney a huge gold star for effort or petition to revoke his law license.
Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Mormon said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on. Private photos between her and John Mello. And so what did she do? Immediately, well, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress is not something that you see very often. Mr. Mormon talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character. He talked about malice, and he said that you got to have an angry heart. He kept referring to me. I said an angry heart, malice. So you're mad at somebody. And I'll leave you with this. Ladies and gentlemen, in regards to an angry heart, just because Zachary Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Told you there'd be fireworks. Wow.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case, and in that regard, it is your duty as jurors to accept and apply the law as I now state it to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony, and furthermore, you should not even mention or discuss any testimony that I have instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I have said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case, and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts and issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either express or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. The defendant is charged with possession of a weapon during the commission of a violent crime, and the state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1. When entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime, or 2. When entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object, or 3. When entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm, or 4. When entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm. Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, a shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon, even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means, there must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location, 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted, 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person, or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson, and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom.
So we find out that the forewoman has already been picked. The alternates have already been picked, and they know who they are. The jury has started deliberating, is our understanding. They left the courtroom approximately 13 minutes ago in real time, as we were on about a 15-minute delay. The judge many times in reading that stressed the importance of the jury not considering or even mentioning those things that shall not be named, that came up several times, especially in Zach's direct testimony. Oh, my. We have a poll going right now. If you're done with the poll, just make sure you've clicked the like button so we know that you're done voting on the poll. That would be great. We appreciate that. We have a dilemma. Okay, we have a dilemma. And I don't know how to fix this, but I'm just going to present it to you as we have it. It is impossible. I could put all sorts of words on the banned word list right now, but it is impossible to keep spoilers from coming into chat. The news will be out on Twitter before we receive any indication video-wise as to what the verdict is. I wish we could watch it first on the video and hear that verdict read in the courtroom as how we would first know what the jury decided. But the truth of the matter is we're going to see it in a tweet first. Someone's going to see it, and somebody who may have never even been to the channel before is going to jump in chat and see it and say, "I just heard. Did you guys hear?" Just know that's what we're going to have. Sequester the room. Yes, we could turn off chat, but that defeats the purpose. We want to have a conversation here, and don't jump on the person who does it. necessarily, but also don't be that person. Okay, let's just. Here's what I can say. Oh man. Spoiler alert: vampires are not real. Thank you, Mrs. R. Appreciate that. There's more than that, because Mercury stars. What if somebody comes in and says, "Yes, I'm so glad he's facing getting the punishment he deserves." Well, what words do I have to block for that? Punishment? Or if somebody says, he'll spend the rest, he'll spend the rest of his life in the place where, he can play the piano for prisoners. I can't ban all the words. I'd have to ban everything in the dictionary, and then it's a pain in the butt to manually unban stuff. But let me stop. It is impossible. It's just know that we are going to find out through chat the verdict, and I can't do anything about that. So, all right. Verdict clock is roughly 20 minutes. Because we're on delay, we don't know when they go out. All I can base it on is pretty license alibis. Let's see. Jury left the courtroom. Deliberations should begin soon. She said 15 minutes ago. 17 minutes ago. So roughly 17 minutes. Let me talk just a little bit about what was the defense closing in particular. First of all, I think the state fumbled a little bit. They did not give a well-polished closing. They hit what they needed to, but he tripped up on things and was bringing in people and names that I don't think he needed to bring up the confusion again. But I think he did, he's like, this is a unique situation, because normally when I'm up here giving a closing argument, the defendant hasn't admitted to everything. Here he has. So it was a little different that way, and I give him credit there. Yeah, it was good. I just think he could have done a little bit better. When defense got up, this was wild. This was crazy. You have him attacking witnesses' credibility, saying, "How could she have seen him on the bike?" You can't trust her view of identifying. Your client admitted it was him. He said, "That was me. I did it. I rode the bike. I wore that. I wore this. I went there." She was wrong a little bit on what he was wearing on his head. But how do you, in good faith, stand up in front of the jury and argue? And in his closing words, he said, "I want you to find Zach Hughes not guilty." After Zach Hughes got up and said, "I did it. It was me." And not just it was me. I did all the things. It was me. I am flabbergasted that that the attorney could do it. Maybe he just doesn't own a mirror and he never has to look at himself in the mirror again. Because how do you hold your head up and say, "Yeah, I'm doing a good job as an attorney," knowing that you just told the jury that killing someone isn't necessarily a crime. Murder is not. Stabbing someone 35 times to death, riding a bike and holding them at gunpoint, forcing them into their house and then stabbing to death, not necessarily a crime, right? It's not. Don't just because those facts exist and they are true doesn't mean my client actually committed murder. That's the big M word. Oh, no delay in verdict. Oh, yes. Verdict will be in real time. Thank you. That is, Judge. I appreciate that. Oh, he argued for jury nullification. He came as close as you possibly can. I think he tried to say it was malice, right? We knew he would bring it back to malice, and he's saying if his intent was good, you can't find him guilty of murder because there was no intent to do evil. Well, guess what? The law views it as the evil act. The evil act is the unaliving. That's what the intent. If you intended to do the unaliving, that's the malice. That's how the law is worded. I'm surprised also that the prosecution did not object at that point. some of his descriptions, his definitions that he was setting out for the jury were a little out there. Yes, we'll have the real-time feed. We've seen worse things said in defense closing. It's their job to defend. But, Jen, have you ever seen a defense lawyer before, after their client admits to the crimes as charged, say find him not guilty? I've never seen the two together. Let's see, we are now in Verdict Watch. We have a poll up right now. It looks like a lot of you have clicked the like button to indicate you have, in fact, taken the poll. Verdict Watch has begun. I'm going to give you just a minute. We've got about 1,200 votes in so far. Chris is like, yay, we'll get verdict music. Stop, you're killing me. I'm sorry. A link to the goat, please. The goat we have, I have actually two goats. These are courtesy of wonderful viewers like yourself who have sent both of these to me. I have two goats and a screaming pickle. I guess we have to, here's the screaming pickle, right? Yeah, we've got a screaming pickle and two goats. I also have a yodeling pickle. The goat link, one of the mods will put up in chat. I have to say, it is an Amazon affiliate link. So if you purchase this goat, which I think is about $8, comes with batteries, I might get 10 cents or 3 cents or something from Amazon as a thank you. It doesn't cost you any more, but that does help support the channel. Those 3 cents add up. Rachel says, now I need the screaming pickle. We need all of them today. The pickle's the loudest, and it's sort of like that's the yodeling one. You can't make it stop either. Beautiful, beautiful. The screaming pickle is definitely the loudest. I think it's just because the batteries are newest and I've had the least time to use it. All right, 20 minutes now into jury deliberation by the clocks. And we have, let me go ahead and close the poll here just 1 second. We've got a little over 1,300 votes here have come in, and let's see where we're at here. The results are as follows. Well, first of all, let me post this one, because I did this during the closings. The poll on the guilt, not guilty, we had guilty at 70%, guilty of lesser included, which apparently there's not available. Sorry, I thought there might be some. 16%, hung jury 11%, and not guilty 2%. That was with 2,000 votes. Now, on this latest poll, I'm going to put this in, it's a little smaller pool as far as the number of votes. We only had about 1,300, but this is right here. How long will the jury deliberate? Over by dinner, 1 to 3 hours is 50%. Interrupt the podcast, that would be the 3 to 5 hour range. 19%. Sleep on it first of 6 to 12 hours. And only 14% thought, they said, warm up the pencil, it will be less than an hour. So we'll see. If it's less than an hour, it's going to be guilty. Okay, I cannot see this jury coming back unanimous in a not guilty in less than an hour. That seems to be a stretch for me. But also I'm not familiar with, the feel on the ground down there. 2AO Toys, welcome. There's some crazy stuff today you can draw from in this case. Let's tell me what you thought. Tell me where you're at now, especially when it comes to the closings. If you want to, we'll open up the phone lines with the burner phone, and we'll keep an eye out for the notice when the jury is going to be brought back in. We probably will have a few minutes after they give that notice for everyone to be present in the courtroom who should be there. Courtney, let me work on that tonight, maybe after the podcast. I'll look on the audio and see if we can clean it up. I realize a lot of the sound bites from this trial as well are just noisy. Not as bad as some other trials we've had, but I do have the ability to clean up and get rid of all that background sound and just pick the voices out of it. And I'll put my considerable skills to good work on that front. We might be able to watch it tomorrow. I'll just I have to look at it first and see what we need to do to it. Kelsbell says, I bought goats for my entire work team. I've never been so loved. Oh, that's awesome. Linda says, I know he'll be guilty, but I want not guilty. He was protecting a child. Linda, I hear you, first of all, and I think that the desire to protect the child is important, and something needs to be done so that can happen, so that protection can exist. The problem is the state was right. He said, you have no evidence to the jury. You have no evidence before you in this matter of abuse. And it's true. And there's no evidence because the judge said it's not allowed in. But based on what the jury has sworn to do, which is uphold the law and follow the instructions as the judge gives them to them, they don't have any evidence to consider. They're strictly supposed to look at not what are the reasons for why he did this, or normally self-defense would be allowed to look at, but in this case, defense of others, the judge says that's not allowed either, with the facts that, or the fact pattern or the allegation that the daughter was abused. They have to just look at it and say, did he commit murder? And I think the answer has to be yes if they follow the law. There's a Christmas goat. I have the Christmas goat. It's the one that's on the white snow, and then I have the regular goat, who stands a little bit lower, but and doesn't have the bell either. So both of them give the same yell as the Pickle. I can't put the timer up because I can't start a timer with an advanced clock. I can't say start a timer 15 minutes ago. But we'll keep track of the various outlets that are tracking it. I'll tell you right now, it's at 24 minutes, according to Law and Crime, 24 minutes. Hello?
Call from Dr. Bullbutter.
Hey, Dr. Bullbutter. This is R.A. How are you doing?
Hey, R.A. Listen, am I the only one with a headache now?
That was a lot to listen to. I don't have one. I don't have a headache, though.
I just can't anymore. My poor goat. My goat is tired.
It's the batteries are low.
I'm tired. The goat is tired. We've gone through all the stages of grief. I just, at this point, I don't even know. I can't believe the defense attorney stood there and started arguing. Well, first he argued that there wasn't malice, like his guy did the crime, but it wasn't a crime. And then when he finished that argument, he launched right into the neighbor didn't see him. It wasn't really him.
Even though he admitted. So stop. Back up to the first thing, the no malice, right? That literally means that any murderer in South Carolina, if this is true, anyone who wants to kill someone else, as long as they did it for a good reason.
As long as they say their
heart was pure. Did it for a good reason. My heart wasn't in it. I didn't.
My heart was pure.
They can kill
and
get away with
pure.
it.
I prayed before. I prayed during. I prayed after.
Yeah, before he even left the house.
My God ratified my killing of this person. I just, R.A., if this happened, but we have seen juries do completely wackadoo things. So I don't know that they're not going to find him not guilty. None of us know that, by the way. Like, I would be guilty vote all day long and twice on Sunday.
So here's the problem. Every single one of those jurors swore an oath and said, we will uphold the law. We will follow the rules as you give them to us, Judge. That was their oath.
I understand that. I understand that, but
wouldn't they have to break their oath then?
I know that, but Zach also stayed on the witness stand and said, like the judge said, don't talk about the cheese pizza. And he looked up and said, yes, I understood, Judge. And then he proceeded to try to talk about the cheese pizza.
Yeah, 3-4 times.
Not everything you say to the judge apparently means anything in court anymore. But I couldn't believe it. Your face gives me life in these situations. I just have to say, it is the best part of court. is watching your face on the screen when it happens.
I have no poker
It's
face.
truly my
If I
favorite
feel
thing.
something, it comes out in my emotions. If I get 2 aces in a hand, I'm like,
I
woo!
love it.
I
It's
can't
my
stop.
favorite thing. It's my very favorite thing. Because
Oh.
I think you were making the face that I was making when it happened.
Well,
We were both making the same face.
Speaking of faces, Pretty Lies and Alibis tweeted out a little bit that while this was going on, the jury was paying very close attention to both closing statements, and one of the jurors just kept like looking at that and looking back at the media and looking at that and looking back at the media. I think we've got somebody who wants to talk, which I'm excited about. I can't wait to hear what the jury, what the juror says when they talk. But
I'm a little nervous because every single time a juror speaks in any of the cases, they get criticized up, down, sideways. Someone is going to be unhappy about something the juror says afterwards. I feel really badly for jurors because I feel like they can't win. They're going to disappoint somebody, and somebody's going to be really mad.
Yeah.
If they come back with guilty, somebody is going to be screaming, "He saved the child. What did you want him to do? That's what he had to do." If they come back with not guilty, the rest of us are going to be screaming, "Jury nullification.
yeah,
You shouldn't have done it."
You've got one side saying, you broke the law, you're making a mockery of the law, and the other side saying, if you find him guilty, you're condoning child abuse, and it's.
Well, my thing is this though too. If you, and I'm not going to say it would be you because I would never like put a hypothetical on you and Mrs. R.A. But if I had a child, I don't, but if I did, and I had a child that was going through something, my very first thing to do would be to take that child to a therapist and deal with issues and then go to authorities. And if I were in Mr. Mello's position and I didn't feel like I had proof and I wasn't getting anywhere, hire a private investigator. Like, there are things you can do, but you don't just all of a sudden graduate to, I have to end someone's existence. Like, that's not the way this country works.
When you consider all other options, right? All other options. I like to think that there are a lot of options. Very times are things just black and white, and you have, you got polar opposites. Those are your two choices, and that's it. Yes or no? Yes or no?
We're saying, otherwise, we're saying Zach is the new Batman, and he's going to see a bat signal in the sky for somebody else being mistreated, and there's going to be another situation. I mean, we can't make him into a superhero. We really can't. He was right in this situation, but he didn't know that he was right. He didn't have the proof in hand, because if he had the proof in hand, he could have gone to authorities. And if he thought what he really did was righteous, and I don't know, if I'm doing something that I really think is righteous, that I think is the right thing, I'm not going to hide afterwards. I'm not going to cover it up.
Yeah, but arguably, he turned himself in.
I would call the police right then and say, something's happened. I need police.
Yeah,
I'd stay.
Dr. Bullbutter, thank you very much. I love talking to you on the phone. I appreciate your thoughts on this. This has been a wild one. Going to need new goat batteries here in just a minute. We'll see. We've got a couple more calls coming in. I want to address this question from Lynn, but thank you, Dr. Bullbutter. Appreciate the call.
Thank you so much. Yep. Bye-bye.
Lynn has this great question. It says, Recovery Addict, can you explain how they would prove the burglary? He admitted using the gun, but no one saw that for him to get into the house. Okay, that's funny, because I think that was one area where the state did very poorly. All they had was this little camera from across the street that showed a shape that sort of looked like him in the same sort of outfit entering the house, like he knocked on the door and then it opened up. They hadn't proved that. But any testimony, that proper testimony that's given on the stand, and by proper testimony it has to be admissible by the judge, is considered evidence. And Zach gave it to him. He said, I had the gun in the box. When I asked, I said, hey, I've got flowers for your sister. And she's like, oh, she's not here. He's like, good. Then I know you're by yourself. Then he said, I pulled out the gun. I told her to be quiet. And then he went to follow her in the house. That was it. That pulling out the gun and forcing his way in, that proved it. So that's where the conviction comes. And it was his own testimony, and only his own testimony, that I think would have met that element of that charge. Let's see. I think he thought what he was doing was saving that little girl. I think that something similar happened to his adopted sister. I also don't think he wanted to get caught because he knew he would pay. I don't know. I do think he didn't want to get caught, but I think more than anything, he wanted that story out. Like that was his goal. Just a Girl Bacon just gifted 5 memberships. Thank you, Just a Girl Bacon. That is super generous. We've got a lot of new people here today, and that is a great way to welcome them in. Let's see. Yeah, you sounded great on the phone, Dr. Bullbutter. It sounded perfect. All right, poll question. If Zach is found not guilty and plays the Beethoven sonatas on a cruise to raise money for SA victims, would you go? Manifesting this to the universe. Probably no, because I've never been on a cruise. I don't know if cruises are ever going to be in my future. Couple reasons. I'm not big into taking vacations, especially ones that cost a lot of money, unless they have a good purpose. My family isn't either, so I don't think anyone in our family's been on a cruise. Yeah, I don't think anyone has. But also, I love fishing, and being that close to water and not really being able to fish, it would be terrible. It'd be terrible.
Call from a person.
Hey, a person. Welcome. Your anonymity is preserved. What are your thoughts here this afternoon?
Thank you. Hi. Okay, I'm going to try to talk low. I'm from this area. I'm from Greenville.
Okay.
I was born in Greenville. I was raised in Greenville. I went to Clemson. I've been to Bob Jones University, whole bunch of it. Okay. Quick question first.
Yeah.
Was Bob Jones specifically mentioned? I did hear, I tried to speed run earlier, today's whole stream, but I was at work.
If it was, it was a passing reference. It wasn't it wasn't the main component.
Okay, good. Because I was going to say, I understand they went there. However, Bob Jones is an interesting place even today. Women don't have to wear skirts all the time as of maybe 7 years ago. But anyway, I guess I just want to preface everyone. I would not be surprised if there was jury nullification in this. Being from this area, this is the most conservative large city in South Carolina. I wouldn't be surprised if it happened. Will it? I don't know. But I just want to tell everyone that. I know everybody's saying, Greenville won't let us down. Listen, Greenville has let me down in a lot of ways. It's a great place. It's also not a great place.
You're saying
it has its shortcomings.
That locally, the aversion to the harm that was being done to the child allegedly is going to be higher than the aversion to murder, right? That's the only way you could get a jury member to say not guilty, right?
I could see that. However, I do feel like they would have to extrapolate out exactly what the abuse was, how bad it was, that kind of stuff.
Which they
but I wouldn't be surprised by it.
Yeah. So
yeah, exactly.
And arguably Zach didn't see it either. I mean, so you're describing the jury's mentality, saying basically Zach did the same thing. He took a drastic action, which all of us thought, oh, why would you do that? Without firsthand knowledge. And maybe the jury would do the same in this situation.
Mm-hmm.
Wow.
Yeah, I'm just saying, it's something I could see. People are very, this is my land, especially in certain parts of Greenville still, protect my land, protect my family, whatever, that kind of stuff. So if there was that kind of extremist person on the jury, I mean, I wouldn't be surprised if they took it more like, oh, this could have been terrible and whatever, and make their decision off that alone.
Would it matter if we've heard that there's a widespread of ages and genders and even races on the jury? Would that change that at all? knowing that it's a diverse jury deliberating?
Would it change it? I don't know. It really depends on how wide that age is. I can see some people, especially older people, being very stubborn. A lot of older people around here are very stubborn when they get something in their mind. So it really just depends on that. It is good that there are other, if there are minorities on the jury, if there are people who will be willing to say, like, no, this isn't what we should do just based on emotions. We should do what's based on the law. If there are people who are willing to stand up and say that, I can absolutely see at least discussion being had, which is a good thing.
Yeah, as long as it's not discussion about the one thing, right? That's exactly the problem. If the jury comes back with a not guilty, I have to think that's got to be against the judge's orders, and then you have to sort of wonder, is this the only order they didn't follow? Right? Because wouldn't it take a little more information into, what is it really alleged? I mean, did somebody go home and read the allegations, the charging documents against Mr. Post, which are terrible, terrible? Is that the level that it would take? And be interesting. It's going to be interesting.
Yeah, I think it's just like overall, like I won't be surprised at whatever the decision is. Like I won't be. Also, I don't know if anyone has mentioned this to you specifically, or if it's been mentioned at all in trial. I believe something like 300 jurors were called to come, and only like 100 and maybe 8 or 9 showed up. So I think that might be a reason why they chose to just give an instruction to ignore what he said instead of calling this trial. Yeah, like, I mean, you can look it up on the news. It's true. Two-thirds didn't show up.
Of the people who received a summons didn't even show to court?
From what I understand. Again, anyone fact check me, that's fine. But yeah, from what I understand, it was a large chunk that did not show up.
That's terrible. This is
yeah. Oh yeah, fairly not great.
Is this because
South Carolina, but
is it? Does that follow through in other civic duties? Like, are there very low voter turnouts historically, or?
I know, especially. Well, I'm not going to get into politics, but
thank you. I appreciate that.
Yeah. So I believe most people will show up. I have been called for jury duty something like 5 times. I was called and almost got on a jury trial for another large case in Greenville that happened like 10 years ago with the sheriff. And from what I've seen, generally people show up. I don't know if maybe it's just January or, whenever they got the summons, they just didn't care. Or maybe they had already heard about the trial and just were like, oh, I'm not even going to go bother. Yeah. I really couldn't tell you. I was surprised by it as well.
Well, now you've got me sitting on the edge of my seat with anxiety, not sure what's going to happen. I like to think I have a little bit of a read on what's coming, but we're just
even the possibility there. I'm really not surprised by it. A lot of stuff pertaining to Greenville. Again, I can criticize it. I love it. I can do it. So I wouldn't be surprised.
Wow.
That's all I just want to say. So everybody, remember, and please don't, if it does come out not guilty for any sort of reason, please don't make fun of South Carolinians. We're not all terrible people, I promise.
We'll reserve that right for Florida. Florida's typically held that spot as far as the juries, because we've seen some crazy things out of Florida. But
absolutely.
I will say that I've got family who lived and traveled through South Carolina. It's beautiful. I've driven through this a couple times, spent some time there. It's beautiful. I love the state. So thank you, a person, for calling in.
You're welcome. I was actually going to say this. Thank you for reminding me. I saw you came after Helene and were cutting up trees and whatnot and helping with all that. You were not very far from where I am.
Oh, really?
Thank you for that. It's very, very kind. We still have piles of trees everywhere, yada, yada, but people coming in and helping us, even though we weren't the worst hit, was very kind of you.
Yeah, it was fun to do. It's like a kid getting to play with toys. I got to take the chainsaw out and the chaps and everything. It was a fun time.
Oh, excellent.
So I appreciate it. Thank you. All right.
Yes, sir. Thank you.
We'll see you.
Bye.
Have a good one. Bye.
Call from Christy G.
Christy G, our courtroom watcher. How are you doing, Christy?
Hey, I am good. Let me turn this off. Okay. I am good. I left, but I was there all day today. I heard the previous caller. I do know that Gigi just texted out that the jury has a question.
Ooh.
I wasn't able to say yes, but I got a tweet from her just a second ago that said the jury has a question.
All right. I missed that, but awesome. Thank you for letting us know.
Okay. Yeah, you're welcome. Yep, they are going back. The jury probably wasn't in the courtroom maybe 15 minutes this morning before they started the closings, just to hear the state ask the one question and put up one photo during the state's closing.
Was it the crime scene photo?
During the yes, it was during their cross. Excuse me, I don't mean to misspeak. During the cross of Zachary, they asked one question and had one crime scene photo up there during that question of her on the floor.
Oh my goodness. Okay.
Yes. Mm-hmm.
Oh my goodness.
And just asked that one question. Sure did. It was all over the the TVs and stuff all in the courtroom. They put it on there. He turned it on, and then he walked, and that's when he said, I have one question for you. And that's when he asked, did you pull her by her feet or her ankles or her arms?
Yeah.
Oh, yeah.
This delayed broadcasting is killing me. It's killing me.
Now, I heard a rumor. Now, I don't know because I'm not like in the whole know out there. I thought that I heard that the verdict, have you heard, all right, the verdict and stuff is going to be announced, I think, live.
Right, but we're getting the question late.
Okay, I don't have the question either.
I've got the question.
Oh, okay. I see. I just saw what Amber wrote.
The jury wants a definition of malice.
Oh my! Wow.
This could be.
That's not good.
It depends which side you're on, right? If I was a defense attorney, I'd be like,
that's
yes,
true.
Yes.
That is so true. Because that's the only way I feel like, I heard one of the callers say that she said it could go either way, and I agree with her there. However, my gut says it's going to be guilty on all. But I just
want to go back and see what the judge said. I don't think he read the definition of malice, did he?
I don't think it came more from the attorneys, really, of what malice was. And if you, in my opinion, listening to those attorneys, the defense attorney made sense, as to some part of it. You can't determine what he felt at that moment. So, I don't know. The jury, they all had poker faces. They were really intently listening. I watched them the entire time, and all of them were just so intent. And listening really hard. So I don't know, the Wynn family with the piano and stuff, the one that got the piano
the house out in the
and
woods. You could walk around naked in.
I believe that is correct. This is not written in stone but I believe Mr. Wynn is paying for his defense. Mr. Wynn and Miss Wynn were there today. Mr. Wynn is also an attorney. So he would whisper the stuff to the defense attorneys, helping, at certain times, like ask this question or whatever. But yeah, I thought that was quite interesting. Like I said, it's not written in stone, but I sat with some ladies from Greenville. I sat with one lady who her husband is one of the bailiffs. So I feel pretty, but is that not interesting?
Let me go back. Let me see if I can pull up the definition of malice from the judge, because I think there was a piece in there that I'm remembering that talked about committing the act is malice, like the idea of the desire to, or the thought of going forward and committing the act is defined as malice. I think that was in there. I might have to scroll around, and it could be a little funny.
Yeah,
it makes a lot of noise,
well, I just wanted to call and give my, just kind of give what I saw today and what the thought, the stuff that I'm feeling. And I also heard that more than likely, I guess this judge and then this court, he's going to make, from what I gather, he's probably going to make them deliberate until they're done, or he's going to request, or he hopes to let them deliberate until they're done tonight.
Oh my goodness. Oh.
And see, I'm disappointed because I had to go, and he never said, okay, lawyers, y'all stick around, we'll give you 10 minutes or, whatever.
Right.
He never said. So I didn't even know how long he would, give a warning out to say when they were ready or whatever. So
yeah.
I'm so ticked off, but I just couldn't stay there the whole, all night. I thought, golly, I went through all this, but, I think I saw the best part.
Yeah.
Oh, I see somebody said my voice is wonderful. Oh, Lordy.
we love the accent. Let me see if I can scroll through live on audio here and find the judge what he said. Give me a second. Christy,
No, I just wanted to call if y'all had any other questions. I'm gonna have it on I'm gonna be listening in my earbuds to you to you and your podcast and stuff like that, so that I can hear when there's a verdict as well. But if you think of something and need to ask, holler, and I'll be more than happy to answer anything else.
Christy, thank you so much. I appreciate your help so much.
You're welcome. I will be listening. Talk soon.
All right. Bye-bye.
Bye-bye.
Okay, here's what we're gonna do. Let me jump back to the replay machine, and we're gonna start scrolling through a little bit and try to hear what the judge. Nope, I don't want that. Let's see. Got some music that I don't need. Let's see. I need that to be gone. Okay, there we go. We need workspace, video clean feed to HDMI. Okay, can you see that? And everyone can hear, maybe? We've got audio, okay.
Sure, due to the value and the evidence presented during the trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary first degree, conspiracy, harassment first degree.
Okay.
The charge in this case, not in this case, and not be considered to you.
Hang on, we've got some updates here. The judge is going to bring the jury back in to recharge them on murder and tell them, yes, malice is required for a murder charge. He's going to read it again. Was it? Okay, I want to see what else is in here. Sorry, I know this is terrible to listen to you guys, but it works for me. I apologize. I realize there's a malice definition that is really good, but I don't think the judge gave that.
Court is creating presumption or inference guilt. These are the formal instruments which may it is formal documents by which this case is brought to the court. The indictment in this case alleged several different offenses against the defendant. Each charge is a separate distinct offense, and he must decide each indictment separately. The evidence applicable to it, uninfluenced decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. Who has a verdict of guilty or not guilty for each indictment. The defendant is not guilty to the indictment, at least the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge
Okay.
Rule of law that the defendant
Here we go.
The law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond personal doubt. Presumptive innocence does not end when you begin your deliberations, but it comes to the defendant trial. Until predictable, based on evidence satisfying you that guilt beyond reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just legal face. The standard to defendant entitlement jury are satisfied for yes, of guilt beyond reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true.
Okay, I've got to find a spot.
Call from
Johnson.
Hey, John, this is R.A. How are you doing?
Pretty good.
What's on your mind here? I'm trying to work with the judge in one ear and answer calls with the other.
Oh, yeah, no, I'm from Greenville, South Carolina too, and I've lived here all my life, and I think I wouldn't be surprised if they came back as not guilty. I personally think it should be a not guilty, and the only reason why I say that is because everybody here in the upstate knows somebody or has been involved with DSS in South Carolina, and they could all tell you the DSS in South Carolina is just straight garbage. And it's not surprising at all that somebody would feel this way about somebody that they know being harmed. And trying to make reports about it, and it just absolutely going nowhere at all. Wouldn't surprise me.
This is interesting, and I mean, when you look at how our court system is set up, we are supposed to be able to have a jury of our peers, right? There's a reason he's not being tried by a jury from people by Greenville, North Carolina, okay? Because we might think a little different than people in Greenville, South Carolina do, and that is fascinating to me. Obviously, whatever the jury decides, I believe that I should stand by it, and that is the right decision. 12 people got together and did this, came up to this conclusion unanimously. But it blows my mind that he would literally say, I did it, but I had a good reason. And they say, yep, we're going to find that you didn't do it.
Right. Well, I mean, is that what they're asking them to find, that he didn't do it, or
to find him not guilty of murder, which means that they would have to. I think the only thing that they could bank on is that there was no malice involved. The state did not prove malice. Could they find him not guilty of murder and then guilty of burglary? Because the burglary requires you to have the degree they charge requires you to have the intent to commit the crime, which they then might not find.
I just don't. I just see the jury not caring about any of that. I mean, I can see them trying to find a way to legally justify it, but I can also see them just saying that they don't care because, I mean, I've smoked many cigars in that same place where that guy hid all of his, pornography and stuff. Used to go there a couple times a week. I mean, everyone here in the upstate knows about that and all the facts that, they don't want talked about in the courtroom. So I just see him ignoring it.
Wow. Oh my goodness, John, this is crazy to me from an outsider, from my perspective. It seems wild, but as I get more and more reports from people locally who are telling me just about the local mentality and the thought process that goes into it, it's becoming more and more likely that not guilty is definitely on the table and not the absurd conclusion that I viewed it as.
Right. Yeah. I definitely see that if they're asking for the definition of malice, then they're looking for a way to legally justify not convicting them.
I would say that we already know that we have people on both sides on the jury. That they're looking for clarification. They're looking for something that they have to follow, a rule regarding a point of dissension.
Right. So it'll be interesting to see what happens. And thanks for taking my call.
Hey, John, thank you very much. Appreciate it. We'll see you. Bye. I am. Oh, okay. We're watching for the video. We're going to get this here in just a few minutes, probably. The jury is going to be brought back in. They're going to be, as the answer to their question, they're going to be recharged, which means the judge is going to read to them again. It probably won't be the entire thing. It will probably just be the part that's relevant. I wanted to find that. Let me see if I can just make the audio happen in my ears and not yours. I think I can do that. Let's see. Then when I find it, I'll switch it back over. Let's do sound local machine only. Built-in speakers. There we go. Okay. So I'll keep listening to that. The definition of malice is very clear in the instructions. Do they not have a copy of the jury instructions? Let's see. When I find it, I'm going to replay it for you. Okay. The judge has already charged them. They've been sent back, but we haven't seen it yet. We should see that part live. Oh, man. Okay. Malice means to intentionally to harm someone. It's the legal term as it's defined in South Carolina that's important to me. Okay. They all nodded their heads when the judge explained. Hey, Mrs. R.A. You have another question?
I'm sorry, guys. I just have so many questions about
you have
this.
to go where we can see you.
I'm going. I don't know if you can see me.
Go a little further. Other side of that pole. There you go.
That pole is a light.
Okay.
Fixture.
That's perfect.
Okay, so here's my question. Did you need me? Oh, okay. Here's my question. If they find him not guilty, are they saying he's not guilty of murder, or are they saying we accept your defense of protection of others?
It doesn't matter.
No, I think it does.
Well, from a legal perspective, how they reach that conclusion doesn't matter. You might have one person who says, I don't think the state proved the case. You might have another person who says that you had a good defense. As long as they all agree on the verdict itself, they can reach it different ways.
Okay, I can see what you're saying. It doesn't matter that way. But to me, it matters, because if we're just saying she needed this to happen to her, then we'll completely nullify the law. That's different from saying, okay, we accept your defense.
Yeah. From a legal perspective, though, not guilty is not guilty, and he can't be charged again.
Correct. But from the point of view of saying jury nullification, the Constitution's shredded and tattered, it does matter. If they're saying, no, we're doing exactly what you told us to do, and we accept your defense that you were protecting someone else as a defense for murder, then you tiptoed around jury nullification.
Yeah.
You're not listening to me.
I'm listening to two things.
I see that glazed eye that it's like, oh, shoot, you stopped talking. Was it a question?
I'm reading chat. I'm listening to the judge, and I'm trying to follow what you're saying. I did tiptoe a little bit around jury nullification, but...
No, not you. The jury. If the jury comes back, this has duct tape on the top of it, and it just pulls my hair.
That's because I'm wearing the nice ones. You're wearing the bad ones.
If the jury comes back and says not guilty, they have two different ways of doing that. They can come back and say, do you just need to listen to him?
No, go ahead.
Okay. They can come back and say, we just don't accept the options that were placed before us, and so we're going to nullify the law. We're going to do jury nullification. Or they can say, we accept what you've presented to us, and this was a defense of someone else. Therefore, that defense says you're not guilty.
That's the problem.
Right?
They're not going to say, for one thing. They're not going to say, and the judge might be coming back in just a little bit, so I'll bring that up in just a second.
But isn't that kind of, I don't know.
The jury isn't going to say how they reached it. They don't return a verdict and say, we are returning a verdict of not guilty because the law is bad and it should account for in the defense of others in this particular scenario. They won't say that. But where you have somebody who admitted to the elements of the crime, and now they have a question about malice. We'll hear about malice redefined by the judge here in a little bit.
Okay, but hang on. If they say we have a problem with malice, we don't think that there was malice there, and there are no lesser includeds, that's another way that they can say you didn't prove this. So there's three separate ways that they could come at this and say it's not guilty without jury nullification. Two different ways. One is jury nullification.
I think it's all jury nullification.
Why?
Because he killed her, and he admitted it. He planned it. It was premeditated. He says there was no other option, but he never. There's no evidence he even called the police. Okay.
I hear that argument.
There are other options.
But the statement is, oh shoot, I lost my train of thought.
If there's no malice.
No. Can they find him not guilty without nullifying the law? And they can if they say the only option is if you find him guilty of all these things, including malice, and they're like, well, we don't find malice, then that's one way to do it. Exactly what they asked him to. They didn't nullify anything. They followed the instructions, and that's the decision they came to. Or secondarily, they can say, we accept that you were protecting her, and so that is an acceptable defense against murder as well. So we abdicate you on that. That's not abdicate, but you know what I'm saying. That there are at least two ways that they could get to the verdict of not guilty without nullifying the law, without thumbing their nose at
the judge,
the law.
the instructions, the law he gives them. He told them that they should not vote based on what they think the law is, what they think the law should be.
Right.
Those are not options.
Right.
They have to follow the law, and so the only deviation where they, in clean conscience, could say not guilty and we followed the judge's instructions is on malice, where we say we found that based on the definition of malice, that element was not met. And these charges do pin on top of each other, and that same rationale would affect the others as well. So you have the murder. If he did not commit murder, which is the first charge, because there was no malice, then he did not commit the burglary as charged, because part of that charge is that you entered for the purpose of committing the crime, which clearly he already determined he did not commit. And then you've got this harassment, which has to be done for the purpose of, and that one would be a little different. It would have to be done. That
one's independent.
With the purpose to or cause that embarrassment or things like that. I think that's the harassment is guilty.
Yeah, well,
but I thought the others were as well.
Yeah, I couldn't think of any way that they could come back not guilty without doing jury nullification. But now that I think about it, I'm like, oh, you could.
Angelo, jury nullification, if you break it down, means the jury votes not guilty, even though the evidence is that he is guilty.
In the teeth of the law, basically, they're saying that law is bad.
Yeah, they're spitting in the face of the judge is what they're doing, saying, nope, we don't believe in that.
I don't think it's in the face of the judge. It's in the face of the senators.
He told him not to do that, so I think he did.
Well, I mean, but I don't think that they're out to get the judge. If they're upset about the law, they're upset about the lawmakers. They're not upset about the judge, I think.
Yeah, the judge cannot overturn it. He can't. If they come back not guilty, he can't say actually he is guilty. Nope. If the jury comes back guilty and there was no evidence to support it, first of all, the judge should have thrown it out in a judgment of acquittal. But there are avenues for him to say, no, you can either reduce the penalty to match the crime that was proven, or possibly enter a judgment notwithstanding the verdict.
So how come they don't have lesser includeds? I mean, I am a big proponent of charge which you're going for. I think that's great. But it does make me curious that it seems like every other one is like, this is what we want, but let the snowball go downhill.
Let's see. Well, this is they've got action going on in court, so we're about to get the jury back. I think they're taking the question. I still haven't got to the part where malice is. I looked up malice in a few places. They all talk about malice as the intention to commit a crime, none talk about anger. Yeah.
Interesting.
I agree. The intent to commit the unaliving, that is malice.
So give me an example of killing somebody with no intent to kill them. Like, that's just an accident.
Well, it's not killing without the intent to kill. Okay, here we go. Hang on.
Madam Foreperson, I've received a question from you. The question, it is define malice, and then the question is malice required for murder charge? And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. Thank you. You can return to your jury room. You can put that back in there.
All right. With that,
Wait.
Yeah.
How is that different from premeditation?
The premeditation, first of all, talk about the evil act, or that he had evil feelings toward her. He said, I mean, he brought up the evil, right? He brought up that his sister was evil, and he saw the same thing in Christina, that he feels she is evil. Is that enough to have the evil intent in his heart?
No, the judge is saying Zach must be evil. Zach is saying everybody else is evil.
Okay, but is him saying that Christina is evil and that she was sucking the life out of people and,
that was Grace. But
no, he said Christina was. He
okay,
saw the
I think
same
you're
thing
right.
that he saw in Grace in Christina. Is that enough?
No, I don't think that's enough. But like he went on to say, if he planned it beforehand, if he, lots of things that check the boxes in this case. But they also check the box for premeditation. So I feel like, hang on, words have meaning. Is malice just another word for predetermination? What's the word I just said?
Premeditation.
Premeditation, yeah.
Premeditation can be a sign of malice, but it does say this evil intent.
It lists that as like one of the definitions, and it's like, well, but if you don't know how they're feeling inside their heart, because who does really, then you can see that they have malice if they've planned. And I'm like, okay, I hear the logic, but also that seems silly because if they've planned, that's premeditation.
This might come down to how the judge reads it, and if it's a comma or a continued, if is there a comma?
Is it a semicolon?
Yeah, I need to know because he was deceived equals evil. He showed hate by his reasoning. What he did is the definition of malice. He planned it.
Well, I think we have several different running definitions of malice.
Let me go back and replay that, okay? Because we now have the definition. I don't have to hunt for it. Let me jump to the end.
Well, he just isn't he what he just did exactly what you're searching for?
Yeah. So I'm going right there.
Okay.
Okay, we're going to replay this just for a minute. Let me give it the audio so you guys get it. And I'm going to pause and break it down as well. Sound goes to you guys. There we go. And we're on 3, right? So bring 3 in. Okay, here we go. Skip ahead a little bit. Here we go. Here they come in. Tyrone, thank you very much. That evil intent could influence them. Listen carefully here.
Madam Foreperson, I've received a question from you. The question, it is define malice, and then the question is malice required for murder charge?
Define malice, and is malice required for the murder charge?
And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought.
Boom. Malice aforethought. They have to prove he had malice aforethought. The aforethought part, I think, is given, but he had to have the malice beforehand as well.
Malice is hatred, ill will, or hostility towards another person.
Is this a comma right here? Malice is hatred, ill will. Let me read that again. I went too fast.
Merely the manner in which malice aforethought does not require act and with an intent.
Hang on, so I'm going to rewind. Does it make more sense backwards for you guys than forwards? Okay.
Ill will or hostility towards another person.
Malice is ill will, hostility, hatred, ill will, or hostility towards another person.
Okay, so hang on. Let's just break it down. Because what else are you guys doing right now? Okay, so say it again.
Malice is hatred, ill will.
Killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act.
It's the intentional doing of a wrongful act.
Okay, so he intentionally did a wrongful act.
Okay, but the wrongful act...
And with an intent to inflict an injury or under circumstances that the law will infer an evil intent.
Or with an intent to inflict an injury, or with an intent under the inference of the law, or the law will infer is an evil intent. Oh,
I can't hear it. But I gotta say, guys, I am a visual learner. Every time he says it, I'm like, can just put text on screen? I cannot hold on to the idea when he's just verbalizing it. That's really hard for me.
I would agree. DSN says he went there with intent. There's no question about the intent in his plan. In his mind, in his soul, in his heart, very much intent. He proved that and did it by his actions when he bought the weapons. Okay?
Yeah.
That was like that act right there. That's prima facie evidence. There's intent. And then as he followed through each step of the plan, that solidifies that. But the question is malice aforethought. Is there malice aforethought in this?
And why do we say aforethought and not just forethought?
Because it's legal speak. Malice of forethought, intent to kill.
Oh.
I think it's a forethought, not of forethought.
Yeah, he does say like it's AFOR, but I think it's easier to understand if we're using the OF.
The less flowery language.
Well, it's just makes sense.
Malice aforethought, the intention to kill or harm.
He did intend to kill.
But he puts this evil intent on there.
I know, but it was almost like first definition, evil or hatred intent. Second definition, planned it out. Third definition, I don't remember what they were.
I don't think they have the jury instructions. I don't think they have notes, and I don't think they have the jury instructions. They were just read them. They have no notes. I know that.
What if they have visual learners out there? People, represent. We need some words on paper.
This is not the trial for you.
That's
malice aforethought is spelled malice space aforethought, AFORETHOUGHT. He didn't say evil intent. He said intent to cause harm. I'll rewind
I think he
one
said
more time.
Both. And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act, and with an intent to inflict an injury or under circumstances that the law will infer.
I think it's safe to say that you can infer that he had hatred.
To accept, press 1. To send a voicemail.
Hey, Donald. Are you there?
Hey, Doc.
Hey.
Yeah, I'm not sure how you can't get to malice when he stabs her 35 times. I mean, that shows he intended to kill her.
Mm-hmm.
And he had hatred. You don't stab someone that many times if there's not a hatred towards that person in you.
Okay, but I have to ask the question because the jury just did. And I thought it was a no-brainer, right? I thought this is a given, but the jury just like, well, do you have to have malice for murder? Meaning
Zach said he didn't.
Zach said he didn't have it. We think he didn't have it. Do you have to have that to convict?
I think you do, but I think that's a given. His actions showed that he had malice. I mean, at least to me.
I would think that stabbing someone to death 35 times in their own home takes a little bit of malice. Takes a little bit of malice in your heart.
Sure.
Zach has presented that he did this out of the goodness of his heart, with pure intent.
Do you think he had very pure intent? But you can have pure bad intent.
And the jury might be buying it. They might believe it.
Yeah, well, they may be, and I kind of worried once he spit out about the child abuse that this was going to happen, that he might get off. But I don't know how you don't get to malice when he comes into her house and stabs her 35 times. You intended to kill her. You committed an evil act of harming her in her own home. And he planned it out. He planned it. He went and got the equipment to do it with, and I mean, this is crazy. In my mind, I mean, I don't see how you don't have malice. I just don't see how you don't get there.
I'm with you. I'm just trying to think like the jury is, because apparently they are thinking differently than I was.
Yeah, me too.
And remember, they haven't had a chance to talk about this yet. This is the first chance that they have to go over this. We've really kind of hashed all of it up to this point. So we're like, what? How are we talking about malice? This is their first shot at it.
Yeah. Donald, thank you. I agree that this case has malice written all over it for me. I thought this was a done deal. And with the jury asking the question, is malice need to be proved? It only tells me that there's at least one in the jury who thinks there's no malice present.
Right.
Yeah.
Right.
Donald, thank you very much. Good talking to you. We'll see you.
Bye-bye.
Bye.
Call from Jen Christie.
Hey, Jen. This is R.A. and Mrs. R.A.
Oh, welcome, fellow Jen.
How are you doing?
Oh, yay. Look, this is like the 5th time I've called.
Good job.
Thanks for being patient.
Well, I keep catching you right as you're answering somebody else, so I go to voicemail. It's fine.
You have to sort of anticipate when the break's going to be. So, what's your thought?
And I'm not a mind reader. So I'm from the U.S., but I'm not from the South, and so I don't probably think like the majority of people from the South, because I'm from very far north. Mm-hmm. And it's just a different world between North and South. Don't ask me why. I don't, whatever. But if you look at the reasonings or the definitions of, like, the legal definitions of malice aforethought, so like intention, he planned it all out. He bought all the things. He did all the things. He brought A and B to the pizza party. Do you know what I'm saying?
Yeah.
Okay. And then he did A and then wasn't going to do A because doing A with the pew pew is a big loud bang bang.
You would get caught.
And then
my
I'm sorry, Jen. You're doing amazing, but it's so funny. Don't use this word or that word.
Just say what you. If you think it's not being clear, just say it.
I'm not trying to get you demonetized with my.
I'd rather have the discussion and everyone be able to follow along and say, "Now I understand what she's saying," or that argument resonates with me. So
but
just
I'm impressed.
Let's keep the cheese pizza out, but the rest of it just use murder, shoot, gun. It's all right.
You can't see me, but I'm giving you the thumbs up. Trust me. Okay, so he planned it all out. He picked out his black outfit, which would not show any blood. He brought paint thinner. He bought a gun. He brought a knife. I think he bought the knife at the place that he bought the gun.
Right, the gun show.
He got the flowers the day before. He got the place with the place he was staying at, the little cabin in the woods or whatever it was called. I forgot. And then he brought his bike. He parked a certain ways away. He rode his bike there. He got his stuff together. He knocked on the door, decided he was going to not ask for her directly, but ask for her sister to make sure nobody was in the house, and it was her. And he used the gun, and he got into the house, and he hit her with the gun, and then he decided he wasn't going to use that. It's too loud. And then he got out his knife and stabbed her 35 times. That's a lot of times. That's a lot of anger with 35 times.
Yes.
And then he drug her somewhere because whatever. I don't know his life.
I think it was out of the hallway, sort of out of view from the front door.
Out of sight, out of mind. And then he closed all the windows and blinds and locked the door and did whatever he was doing. And he saw himself in the mirror, noticed that she scratched him, tried to clean that up with some paint thinner. Like, all of this is intention. All of this is malice aforethought. All of this is planned, premeditated. It doesn't matter what happened to the daughter. I don't mean that like that. Right. But it doesn't matter what happened to the daughter. He didn't know that was happening. He heard that was happening, but there was zero proof that time.
Right. The police had no proof, and he didn't have any proof to give the police as well.
This is what I'm saying.
And more to the
so
point,
I don't.
Even though it looks like it probably is true, even if it is true, this is not the way. This is not the way. You can't do this.
Right. Because we are a society that does not take matters into our own hands. That's why they have police officers and laws and rules and regulations and judges and all the things, because we are a... Go ahead.
Keep
You're
going,
so
keep going.
patient. We put placeholders not because we have something to say immediately.
I just
but
talk when I get an idea in my head. You continue. Continue. We're a society that doesn't take law into our own hands.
Right. This is not the wild, wild west. It is not eye for an eye. There is things that he could have done, and he didn't. He did things, but it was not truthful things. Like, it was fake things, and he did not call the police. He called the people that deal with the cheese pizza stuff. I can't. My brain is moving so fast, and I'm so nervous. My whole body's shaking.
You're doing amazing.
You're doing great. This is.
I don't understand if they don't get to guilty, because that's what he is. All of the boxes are checked. This happened, check. This happened, check, check. This happened, check, check, check. All the checks are checked, because, whatever. And if they don't get there, I don't understand how they're not there, because it doesn't make any sense. If people don't like CPS, CBD, whatever, I don't know what they call it down there.
All the letters.
DHS, VHS,
DCF,
whatever.
DFCS.
VCR, whatever. Yes.
ACDFG.
ACDC, whatever. That doesn't have to do that. That is not what they have to follow per the judge's rules. The judge makes the rules. I mean, the judge doesn't make the rules, but the judge tells them what rules they have to follow.
I'm just,
you know what I'm saying?
I want to look at this and I say, is it possible for the jury to come back with a not guilty verdict without it being a miscarriage of justice?
No.
Ask the question again.
Is it possible for them to come back with a not guilty verdict without it being a miscarriage of justice? Because I do believe that I don't think any of the jurors are down there. You know what? I just want to stick it to the law. I think it would be really funny if we found somebody who's completely guilty and we just said not guilty, just to be like, we can do that. I don't think they're doing that. I think every juror is going to cast their ballot and say, I believe in my heart what I did was right today, and that I stand by my conviction of not guilty. If they choose
right,
not guilty.
And so does, and apparently so does he. But that doesn't mean it's the right thing.
I agree.
You know what I mean?
It's a false dichotomy. We're stuck in this place where it's like, do you love children, or do you believe that people shouldn't kill? And I feel like, I don't think. Yeah, exactly.
You have to choose one.
The answer is both.
Yes.
No, I cannot.
Exactly, but that's what the jury. I believe that's what the jury is feeling when you just boil it down. That's what they have to choose, and that is hard.
If that is the way that they're thinking, this is a sad, sad world. Do you know what I'm saying? Like, it should
talk
not
more
be
about
one
that.
or the other. It should be all.
Agreed. 100% agreed. But in this situation, that's the dichotomy that they've been given. So it should be both. We should be able to say yes to both. But how would a jury vote to say yes to both?
I don't know. Maybe they say not guilty on murder, not guilty on burglary, guilty of harassment. Is that how they rationalize that he's guilty for, he did something wrong, but we
I mean,
think
you
he did
can
it for the right reason.
not you personally, but people can rationalize things 20 ways from Sunday. That doesn't mean anything. You know what I mean?
Yeah.
Just because you think something is that way doesn't mean it is that way. I don't know. I just wanted to throw in my 55 cents or whatever. I got more than 2
Jen,
cents.
you got your money's worth out of that.
That was good. That was well articulated, and lots of people in chat are like, "Yay!"
I appreciate, particularly Jen. You did a fantastic summary of the case.
Yes, you did.
The wrap up. That was. How much do you charge for those? 'Cause I'm terrible. At
Would
that.
you mind if we just make a thumb or a little quick?
We'll call you and record cases. Summarize them for us.
Well, I listen to cases all the time. I don't just watch you. I watch
Awesome.
you and Lawyer and Emily and
good. Me too.
And all the people.
They are fantastic.
And
they are.
All y'all are all fantastic.
Well,
and I did go to a little bit of school for a little bit of law stuff back in the day, 1,242 years ago. But I pay close attention. My ADHD, if I'm doing 5 things, I can pay all of the attention. So I pay pretty close attention.
Yeah,
that's pretty cool.
Jen, you've done a fantastic job.
Yes.
I can't wait to hear more on future cases from you.
Yes.
On the burner phone, especially summaries.
Yes.
Well, you guys have a great day, chat. You're fantabulous, and hopefully they're back quick.
Tell us again, what's your name in chat, Jen?
Oh, it's Jen Christie, 76.
Awesome.
Sweet.
We wanted to make sure everyone knew who you were so they can say you were my soul sister in chat. Thank you, Jen.
All right, have a good day.
All right,
bye-bye.
bye-bye. I apologize. I did miss a couple calls. I know some people are calling. I can only take one call at a time. I don't have call waiting. The burner phones are cheap. That's by design. Okay, so they're meant to be thrown away.
You guys are so articulate, and don't if you're out there saying, "Oh no, I can't call in because I'm not." Everybody is. You guys are really good at stating your
fantastic. All we ask is we don't make just far out speculation of accusations against people, no name calling, and things like that.
Melissa.
Oh, here we go.
To accept.
Hey, Melissa, this is Scott. How are you doing?
Hey, Scott. Is everybody forgetting what the trial's about?
Maybe. Please do remind us.
I mean, this is what everybody's going to the child abuse and everything that happened. That may well be true, but this is a murder trial. Mm-hmm. This is about a guy that burgled a house, got in under false pretenses, and killed a woman.
I wonder if it would have been better for the state for them to own up to that. I think Josh mentioned this last night in our little discussion about this case on Courtroom Confidential.
Okay, I didn't get to watch all that. I watched part. I didn't get.
He's so good. I'd say go back.
What
and
I
watch.
saw was good. I will watch the rest.
He said, "What if the state just owns up to it and says yes? There, in the investigation into this crime, we discovered another heinous crime that occurred.
I think so.
Arrest has been made." And charges are pending. That will be fought in another courtroom. Justice will be sought in another courtroom. Now, I realize that one of the people that's allegedly involved in that can never face justice if that was what was coming, because she's dead now.
Right.
Allegedly, I have to put allegedly in there somewhere. But
I mean, it's just all I'm saying is the judge admonished the guy 3 times, said, you need to disregard everything he said. You have to do that as a juror. I mean, you have to, in a trial, maybe some people don't agree with me, but that's what a trial's for. You can't judge on something that the perpetrator brought in and said.
Yeah, I think what we're seeing here is this legal system, which we love, is showing that it's not perfect.
Oh, right? I know. I get it.
I like to think it's the best system that's out there. I haven't seen anything better, but it isn't perfect. It can't account for all these scenarios. And the best we can do leaves us leaves us frustrated one way or another. Either justice was robbed, or justice wasn't justice was wasn't served where it needed to be served.
I get that, but I still can't say anything bad about the prosecution because they were so blindsided that I know they had time to think it over, but I feel like they thought they couldn't go back. You know what I mean?
Yeah.
I feel like they thought they were on the spot, had to continue with the trial. And I feel like everything in the prosecutor's last statement said it all. After you killed her, did you drag her by her ankle or her wrist? I don't remember. I think it was her ankle. So, I mean, I get it. Child abusers are the scum of the earth. I mean, honest to God, child molesters are the scum of the earth. I can honestly say if one of my children had been molested, I could probably kill. I mean, I could probably do somebody in over that, but I'm just going back to what this trial is all about.
Yeah, the trial is the charges, as charged, and that is ancillary. It happens to be connected, but in this case, the defense has said this is the reason why. So, appreciate the call. Okay. Thank you very much.
Yeah. All right, you're welcome.
Thank you for
Scott.
calling.
We'll see you.
I love you, R.A.'s wife, because you say it just like you think, like I do.
She's amazing.
Yes, I do.
Thank you so much.
You're a good person. Bye-bye.
Thank you.
Bye.
Call from Bite Me.
Bite Me. It's Rebecca.
That was funny, Rebecca. We just got you saying just bite me, and the way it came in, it was
Bite
funny.
me.
I happen to know that your name is Bite Me, and you count mosquitoes for a living. So, but other people might not know that. What's on your mind, Rebecca?
This is the 5th time I've tried calling.
I know. I feel bad not being able to answer all the calls. We've got a second jury
That's
question.
Okay.
For real?
Okay. Oh, okay. I want to know real quick because you are so busy with phone calls, but I want to know if there's one person in there that is questioning whether there's malice or not. How are they, that one person, coming to the conclusion that there was no malice?
Coming to the conclusion there was no malice. Sorry, I hit the wrong button because I got a phone call and it pulled up on my screen. How are they, the jury, coming to the conclusion there was no malice?
The one person that's possibly, maybe two, I don't know how many.
It would have to be that
they've asked that question.
It would have to be that the jury, different members of the jury, understand malice differently. They're working from a different definition of malice.
Well, and the judge gave several definitions of malice.
It was we've got about 30 seconds of malice definition.
I personally do not understand how they can say that there was no malice. Because any way you look at it, there was malice to me.
Yeah. See, I'm with you, Rebecca. On this one, I see that malice is the intent to take someone's life. Like, I intend to kill that person. That to me seems like that has malice inherently in that thought.
Right.
Where the way the defense has played this in presenting this to the jury is that it had to have been evil in his heart, and this might be playing on the local culture a little bit more than it resonates with the rest of us, as we've heard from a lot of the locals that evil heart, the intent to I mean to do bad. Had to exist. And they're saying, no, but there was an intent because he meant to do good.
If you asked me walking on the street and you're like, hey, define malice, that's how I would define it. So I don't think that they're like, oh, you're such bad jurors because you think that's what malice is. That's what I would think it was. Malice is anger in your heart. Now, I get there's a legal definition and it's different. I understand that. But I don't think that they're like stupid or incompetent or anything if they think that that's what malice means.
I don't think that
whether, I don't think your heart has anything to do with it. The intent was there. I mean, he had weeks to decide to do something else. And he intentionally went and, he prepared for it and planned for it. And whether in his heart he thought he was doing good by getting rid of her, the actions prior to that, to me, indicated malice.
Okay.
I'm with you on that. My understanding of malice matches, but I think that the jury here is using a different definition, talking about that evil intent. And this goes back to the opening for the defense. They tried to say, hey, they're trying to tell you he had malice. We're saying he didn't. He didn't do this with evil and hatred and everything. It was with regret and remorse and pity, right? I only feel pity for her. And so, this could be an incredibly well-crafted, manipulative story that they've concocted. Or they're trying to play the letter of the law to get around showing he had no anger in his heart.
Yeah, well, I have to disagree with that side of it too, because for him to say that he only had pity on her, he didn't, because just the way he spoke about his sister with the hostility he had toward her, about how evil she was, and he compared her to Christina, and I to me, that's not pity.
Yeah, I agree. He did
That's
describe
not pity.
Pity in the moment that he was committing the act, but you're right, as he was describing it earlier, that was not pity.
No, that's not pity.
Yeah.
And, so I'm just having a hard time understanding how they could come back saying that there was no malice. What was the last case we had that they came back as not guilty and we were shocked?
Colin Griffith, the boy in Florida who 2 years prior had shot and killed his dad in an altercation.
And this is a theme.
And then
the mother and the father.
The mother and the father.
Yeah.
This is a theme that I have noticed. No, please go.
Well, see, I have a hard time understanding how they came back not guilty on that one. But it happens.
Yeah.
Yeah.
But for reasons we don't understand, apparently.
I'm curious how I'm curious if the jury how they can rationalize in their head, how they can get to there was no anger in his heart without considering the reason he was doing this. How can they, without knowing, say, strike from your mind any mention of the abuse that he believed was the child was suffering at the hands of the mother. If you take that out, which the judge has said is not allowed, they can't consider it though. How do you get to?
Yeah, you can. You can, because he could have done it for any other reason too. What if he was pissed off at her for shoplifting or looking at the wrong way at somebody else? People can just go off for any reason they want. In their mind, they justify it.
But I don't know if the jury could look at that and say there was no malice, because he just said, I just felt pity for this woman and I stabbed her and she died. And it revolts me too. It was revulsive to me as well. Is that the right word? Repulsive?
Repulsive and revolting.
Revolting
It's all of them together.
Yeah,
I'm making new words here.
Yeah. That's okay. We do word salads all the time.
We're waiting. I don't know what the new question is yet. We just know there is a question.
I'm quite curious to hear what the question is after asking about malice and knowing that all they get is somebody saying it out loud and they have to just hold it in their brain. I am curious to see which way this goes. This is such a sticking point for me, but I think if I had it written, I could sit down and I could parse it and make sense of it. But just him saying it out loud, even twice, I'm just going to pick up pretty much what's going to happen is I'm going to hear him say the words that validate where I am already coming from, wherever that is. I'm going to say, see, he said whatever that supports my point of view, and that's all I can hold on to in my head. So for crying out loud, kill a tree, print it, and make it possible.
Give it to the jury in black and white.
I know. That's all I'm saying.
There goes the tree.
Y'all, I enjoyed talking to you. I know there's a question coming up, and I just drove into my garage, and Buttercup is waiting for me.
All right, give her a pat.
Let her
from us.
out into the backyard. she smells the fried chicken I picked up. And so she sends butter sugars to everybody.
All right, Rebecca,
Okay.
thank you so much.
Thank you.
Miss R.A., I love you. R.A., I love you
Thanks
too.
for calling in.
Thank you. All right,
Y'all are fabulous.
We'll see you,
Thank
Rebecca.
you.
Bye.
Okay, bye-bye.
This is amazing. Do people tell you they love you all the time?
Nonstop.
That's amazing. No wonder you have such a great self-esteem.
I love all you too.
Call from Carolyn Thompson.
Hey, Carolyn, this is R.A. and Mrs. R.A. How are you doing today? We're awaiting a question, so I might have to interrupt you and tell everyone what the question is from the jury. But what's on your mind today?
I cannot get over the fact that the defense attorney said you can kill someone and it's not a crime. I'm sorry, what?
I'm sorry, it's not funny, but it's so absurd.
I need to find that.
What?
Where was that moment?
I'm
I've
with
got it
you.
on replay.
I listened to that and I was like, that's what you went with?
I'm in California and I'm like, what? We can do that now?
Just because you broke into their house, stalked them, waited till they were home alone, brought a gun and a knife, and stabbed them to death does not mean it's murder.
Okay, and did you see the way that he confused it? He used a logical fallacy right there. So he was like, it doesn't mean that you've actually committed a crime because, and then he starts explaining that he doesn't have the responsibility to provide evidence and provide a case that would sustain himself, although that's not true if you use self-defense. But anyway, throw that part out. He said, I'm going to use the logic of it's not my job as the defense attorney to be able to prove my innocence. And I'm going to use that logic and apply it to the defendant, so it's not his job to be found guilty of something he confessed to. I was like, whoa, where are you going there, kiddo?
I'm going to prove it with almost zero.
I know.
He was dancing on the edge of a dime. There was so little footing for him on that argument that he even struggled to say it. I don't know if he's ever managed to.
You can see his body was like revolting.
Yeah. We might have a question here in just a moment.
Okay.
Wait, I've got audio turned on, so the judge might interrupt. I'll be able to hear. You won't, but I'll just cut you off.
Sorry,
I just wanted to say, love you guys both. Thank you so much. And yeah, I can't get over that.
Thank you.
Yeah.
I appreciate it. Thank you so much for calling.
Thank you.
Bye-bye.
Bye. You get so much love. I mean, they're loving on me too, but wow.
They only say that when you're here.
I don't think I believe that.
You're wrong again. Okay. Who is this? Hey, this is R.A. Who's on the phone?
Ryan.
Ryan, how are you doing?
I'm doing great. How about yourself?
Good. I don't want to ask if you love me, because...
You have to say
I love you both.
There we go. She loves us both.
I love you both equally and the same, just like every good.
Yes.
Like every parent
and I have no favorite children. Yep. All right. What's on your mind?
So I'm going to preface everything I say with, I think that he should be convicted because I don't believe in third world vigilante justice. Just saying it now.
Okay.
But, so I've had to have like the definition of legal malice broken down to me about 1 billion times because I know that there's a difference and it's so nuanced and it's like splitting hairs different. And so I guess my point is that it is very different, but like we're asking the jury to do that. Like we're asking the jury to split those hairs, you know? And there's one, so like, I had to look it up before I called because I kind of remembered it, but if you use Black's Law and look up malice in criminal law, there's a caveat to me that I can see where somebody on the jury would get hung up on because it's like, signifies a wrongful act done intentionally, comma, without just or excuse. And if you listen to him and you take what he says is true,
I didn't
because he was
comma. That changes
I told
that.
you, punctuation, the whole thing could swing on
It's
the comma.
good. Seriously. No, that changes that sentence.
No, it does. Have you never heard of the $1 million comma? That's like a whole lawsuit.
Yeah. But I mean, the way that you just read it, I was like, oh.
Read it one more time.
So, and I'm going to give you the whole thing for context. So Black's Law malice is in criminal law, in its legal sense, this word does not simply mean ill will against a person, but signifies a wrongful act done intentionally, comma, without just cause or excuse.
Okay, we're back in court. Hold on just 1 second.
Okay, ladies and gentlemen.
Yeah, hang on.
I received your question asking about first and second degree harassment. Harassment first degree. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1. Following the targeted person as the targeted person moved from location to location. 2. Initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted. 3. Surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person. Or 4. Committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Harassment second degree. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including but not limited to a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. Okay? You may return to your jury room.
All right. Thank you for staying on the phone here. We're gonna cut back because we lose the audio right now. Stop for just a second, though. Thanks for being patient, first of all. We are close to a verdict.
I totally forgot that I had you on mute.
You're talking to him.
Glad you didn't just start some other conversation. We're close to a verdict. The jury is on the 3rd charge. They've got past murder. Oh, wow. They've got past burglary. They're now talking about the last charge.
And if they found him not guilty of the first, then burglary is like, we're done with that one.
Yeah, burglary is going to go hand in hand with the first one. The last charge is the only one that's separate, and I think
hang on, it's true the other way too.
Not guilty.
It's the other way too. If they found him guilty of murder, then burglary then he's guilty of that too.
Oh my goodness.
But they're going through them.
I'm with you,
really fast.
Mrs. R. I'm so with you. I'm such a reader by hobby and nature, and like I'm a very visual. Like I need to be able to write and hear and see it all at the same time.
Yeah.
So yeah, it all makes my brain swirl. I mean, so you think? I guess because now I'm having you recap because I totally forgot that I had my phone on mute and that I had my computer on mute, so I was just staring here into space.
Sorry, you missed the question.
Nothing happened.
I did.
No, I'm kidding. Something happened.
So the question was, the jury wants to know what's the difference between first degree harassment and second degree harassment, and the part that stands out there is the this action was done without reason, without cause, without purpose. It was just to harass. I think the jury's going to say, well, there's clearly a purpose, a good purpose.
Second degree, though, I listened to that. I was like, dead to rights. There's no wiggle out of that one.
I don't know.
Like, I think that, like, I agree with everybody that has very passionately and very eloquently stated, like, why they think that he is guilty, because I also think he's guilty. I also know that we are also coming from the perspective of not being a juror and not having somebody's liberty and life in our hand.
Mm-hmm.
That's true.
I respect that, like, that even if they come to the decision that maybe I don't like, it sounds like they've thought about it. That's all. That's all we can ask for.
Right. But honestly, I don't want this guy out. I just feel like a good argument can turn this guy into a weapon. I don't love that.
Kathy from Gossip Room in Innuendo says, I think he should be not guilty. I just don't want him to live near me once he gets out.
Or not even living near me. I don't want him to know anybody who knows me. I'm like,
there's Kathy right
well,
there.
I don't want other people that have I don't want other people to see this and copy it in the sense of, like, because if he's acquitted, then it's a justification to some other not very sane person to do something. Like, even though our system in a lot of ways blows, if I can say that, like, DPS is hard and the law enforcement. I know. I just remembered that I've said this. There's no delay for me. It blows bubbles.
Yes, that's what I thought you were talking about.
Yeah, I'm totally chewing gum. But yeah, but all those things, like, even though all those things are faulty, it's still a matter of we can't do that to someone else, even if they're doing something really awful. Short of, I don't know. I'm being contradicted to myself.
No, I hear you.
And I'm taking time.
The fact of the matter is,
I'm taking all your time
if
up.
the jury comes back and says not guilty, you will have a defendant who came, what I think, pled guilty, pled not guilty, got on the stand, confessed to the crime, and then was found not guilty, which blows my mind.
But
bubbles.
Again, I just want to point out that they can do that without jury nullification. They can do that and they say, I accept your argument of defending someone else. That's why we find you not guilty. So it's not as bad. It's bad. It's pretty bad.
Yeah.
I guess that was my point. Whenever I was calling originally was not because I was defending anybody or him, but saying I could see how someone on the jury could be getting hung up, very much so within the confines of what they're being charged with. And even though, like, the definition I read is not the definition that he read, but if you have somebody that's law adjacent who has just, like, that little bit of understanding,
right?
That's kind of what my original point was. Is that was that there's that aspect of it. I just lost all my train of thought.
And something you said earlier was talking about these guys are in the jury room and they've got the whole weight of his life and forever sitting on their consciences. And that's so real. And I think something else is they don't have us, right? Our conversation is sort of evolved and refined and found its direction as it's gone. And I'm not saying that we all agree with each other. I'm just saying we are shaping each other's opinions as we discuss it. That same thing is happening, but possibly with wildly different results in the jury room. I don't know.
Right. And we're bouncing these things off and we're evolving and kind of changing even our opinions or our thoughts on it as it in real time, because we can talk about it and they've had to, like, store it. So what percentage of our memory recall is terrible?
Like 95 of mine. Was that like a real question? A lot. A lot of mine is bad.
I was going to say, I remember about 4% of anything that comes through my head at a given moment.
Yeah. Unless it's written. That's all I'm saying.
Yeah. Yeah. So that was all, like, I don't know. Like, I guess I'm trying to be the cheerleader for the jury. Like, you're doing a good job.
Go, jury, go. Please don't be watching us right now.
Don't let us down.
Yeah, don't watch us.
Yeah. Oh, man.
Please don't acquit him, but also, like, do your job. But I mean, I guess my point is I can't imagine, like, it's a lot. Even if it's the right thing, it's still a weighty decision.
Huge. All of these cases are huge. Yeah.
I don't know.
If you don't shut me up, I will never stop talking. So I'm going to stop talking.
Oh, you are a girl after my own heart. I love that.
Thank you so much for the call. Please call again anytime.
Yeah, no problem.
Thanks.
Right, we'll see you.
Bye-bye.
Bye.
I saw Josh from Court Confidential is in the chat saying the tension's killing him. This is just going nuts. There he is. Josh, thank you. I had a blast on your channel last night. Thank you for letting me fill in some very big shoes. and do a poor job at it. So.
You did great, but I gotta say, it is becoming more tense for me. I came into this, I never really have a hard time arguing the other side when I feel secure in the fact that it's never gonna go my way, right? So I can stand up for the underdog kind of thing. But now it looks like maybe it'll go that way. I'm like, oh, guys, but no.
We need like a light on you. We'll give
Sorry,
you a ring light.
just so you guys know, I have to go mom every now and then, so it's easier to do if I'm not lit.
Yes. She just drops the headphones, I mute the mic, and she's off. All right.
Call from Leah.
Leah, you have a super soothing voice.
Leah, please bring us some peace and comfort. Talk to us for a minute.
Well, then, thank you very much for the warm welcome, because I'm super nervous to talk on your show. So, what I wanted to say real quick was I honestly don't believe that he even cares what the jury comes back with. I do believe that he wanted to bring a situation to light. Mm-hmm. He did it in a horrible, horrible way, but he's kind of resigned to the fact that whatever happens, happens. The girl is safe.
I believe that is how he felt when he made his decision. Do you feel like he still feels that way today, staring down? Is it a life sentence? Staring
life.
down like an actual huge consequence for what he did. Do you think he still feels that way?
I don't know.
I think he
know
does.
You do?
Because 6 months in jail, he's like, I understand. Yep, I go into this fully knowing.
At least.
Yeah, so he's already got 6 months on his sentence, and that didn't dissuade him.
Has he been in jail?
He has been in custody, but he just got another 6 months.
I know, but like it's one thing to say, sure, I'll do jail. It's another thing to have done jail and say, I'm willing to go back.
Yeah.
That's interesting. That's an interesting take.
Yeah.
It could be. He certainly was willing to spill it all to get his story out there.
Yeah, that's why I'm kind of thinking that he's like, whatever happens, happens. That girl is safe. Let's bring light to the fact that maybe the CPS or whatever you guys call it down there, whatever they call it, may not have the best process. This girl is safe. The other girl that was named is safe. And I don't know. But that's my take because he seems super calm. He's very well spoken. He seems like his heart was beating less fast than mine is right now. I mean, he seemed like he was, really just, this is my story. This is what happened. And I'm going to tell it. And
super articulate.
Whatever you guys decide. Yeah.
He did a good job explaining. So. You never felt like that doesn't make sense or you left a hole in your narrative or that you're getting too emotional. I mean, he just plod along.
Yeah.
Yeah.
Great thoughts. And thanks. You have a very soothing voice.
You really do.
Thank you. Thank you guys.
Thank you for calling and sharing that with us. I appreciate that. Give me your name one more time.
Yeah.
In chat.
Leah.
Is that
Leah Bell.
Leah Bell. All right.
Leah Bell.
Thank you, Leah Bell. Appreciate that.
Yeah.
Good talking to you.
All right.
Bye.
Yep. I will keep listening. Have a good night.
You too.
Me too.
Bye. It is.
This office
we're
is
about
like
2 hours into deliberation. It's what?
It's like going to Vegas. I have no idea what time it is. It is always the same lighting in this
we
room.
Pump oxygen in to keep you awake. all the slot machines by the doors are the ones that pay out. It's like Vegas here.
I do not. She said, "Have a good night." I'm like, is it nighttime?
We've got the podcast tonight in just a couple hours. Your car's extended warranty. Thank you for your generous gift of 10 gifted memberships. Also, Katie Bug, thank you very much for a huge super chat and the kind words. We've got also Ricky C comes in with another 5 gifted memberships, and Courtroom Confidential. Josh, thank you as well for gifting 5 memberships on the channel. You're amazing.
You guys are all really amazing. I am so grateful that you let me come in here and talk because it limits how much he interacts with you, and none of you have gotten on to me like, get off the bike, I want to turn. I really appreciate that. Allie
B also sent a super chat. Allie, I'm sorry, I didn't know you weren't aware that we had lost a mod, that Sharon had passed away. It has broken our hearts, and we miss her terribly. But thank you for the kind words there.
Call from
Pierce.
Hey, Pierce. Pierce, are you there?
Yep, I hear you.
All right. Are you typing something? A manifesto or something?
Don't don't type a manifesto.
I just moved something around.
All right.
Sorry, first time caller.
Oh, you're great. What's on your mind?
Love you guys. What I noticed while he was on the stand, and he was saying that he felt so bad, but there was no emotion. If I was a juror, I would notice that and be like, this guy is just putting on a story. And that's what I feel.
Okay, so you think that he like crafted it, came up with a narrative and just shared it?
Yeah, that's what I think. I think in between his defense team and him, they're trying to put on a story. And yeah, because there was no emotion. Even when he said he felt pity, besides the time where he showed that moment of disgust. I think it was when he was talking about Post.
Yeah.
Brad Post.
Yeah.
But that was the only time that I saw
he was
any
in
type
such
of
control
emotion
throughout all his testimony.
Right.
He also didn't have anything thrown at him. He only defense questioned him.
Right. There was no hostile moments where he had to confront something he didn't want to talk about.
Except the
but
judge.
When he said it, everything repulsed him. It repulsed him to do it, but there was no repulsive
I
face.
see.
You know what I mean?
Yeah. You're saying that
there was nothing.
His body language and his emotions did not correlate with his words.
Right, with his words.
Yeah.
So that's why I think he's guilty. That's what I think they came back with, at least I hope, because I live in the area and I don't want him around.
Right. Yeah.
Oh, my goodness. Oh.
I remember, this is only sort of connected, but one time Scott and I went to a party and everybody at that party was soused. Like, not buzzed. They were drunk. And I'm looking at this full parking lot of cars and all of these people. I'm like, Scott, we got to go. I don't want to be.
We have to beat them out the door.
I know. I'm like, I don't know who the designated driver is, but it does not matter. We've got to go. And that's kind of how you feel. You're like, I don't want to be here. This is not safe. This is not a good thing.
I've been there a few times.
Yeah.
Been there in areas a few times like that.
Yeah. What's your name in chat? Give me that.
Unidentified co-conspirator.
Oh, awesome! I've seen a couple remarks from you. Thank you.
Sounds like a confession.
Yeah,
it might be a manifesto.
If you have questions, if you have questions on certain things, Grok on X, is super helpful because you can say, "Hey, break this down in layman's terms in regards to South Carolina law," and it will break it down in kindergarten level.
You know, I
that's my
I was asking Grok last night because I'm looking for a place to go metal detecting. So I'm like, show me properties for sale that have historic swimming holes on it. and it can do that. It's like, well, there's this one here, there's this one over here.
I'm having all these images in my head of like skeletons floating on the water. I'm like, what do you mean historic? What does that mean?
Yeah, it's fun. Co-conspirator, thank you very much for the call.
Yep.
Please do call again.
No problem. Thanks for taking it.
Yep.
Yeah.
We'll see you.
Have a good one.
Bye.
Love you guys.
You get it from everybody.
What can I say? I'm just a lovable guy. All right. Let's see. Jury can believe all or part of the testimony. Zach was trying to save his skin with his testimony. 100%.
Call from
let me just say,
proud no spouse.
Proud male spouse, you might have to turn your volume down while you do that. Let me just say, the callers have been fantastic.
Amazing.
The insights, the thoughts, you guys are absolutely incredible.
Yes.
And with that,
and
with that high bar,
much.
proud male spouse, what's on your mind?
You're going to be graded.
Yes.
Look, I already get a good grade. I sent your children Legos. Okay,
yes.
come on.
Oh my goodness.
A+.
They loved them.
Oh my goodness.
Oh, good. I'm so glad.
I
told you I'm going to be prosecuted in Legoland because there are so many dismembered Lego bodies in there. It's crazy.
I dismembered them once they got here. I was like, hey, look what I can make with this.
It's like Batman, Donald Duck, become Bat Duck. Yes, we did that. Thank you so much, by the way. The kids absolutely love them.
Yes.
And that's wonderful.
Good. No worries. So everybody keeps talking about his body language, and I'm fascinated by it. And I legitimately went and did a contact us request with Dr. G Explains because I want him to break it down. I am dying to have someone that has some sort of education and background go through and break this down and talk to us about it, because we're sitting here speculating and we don't really have any idea what the hell we're talking about, but we think we do.
Yeah.
So, which makes us just dangerous.
Yeah,
it is. It's absolutely
awesome.
dangerous.
I'll text him as well. I got his personal number, so I can reach out that way.
Oh, was that a little name dropping?
Because I just sent him an email. So some random person that he's never spoken to, whatever, and I'm sure he gets requests all the time. But I'm fascinated and I'm dying because yes, there's just I can't put my finger on it. I don't know exactly what it is, but something is off.
He has a very flat affectation.
There might be very little for him to go off of, but the little things you can see might be very telling. So,
Dr. G?
I don't know. Yeah, he's very insightful. I find him fascinating, but it's just I don't know. There's something not quite right, and like everybody's been saying, it's like, look. We're sitting here with hindsight on this. Yes, there's a whole bunch of things that have come out after the fact, but you're sitting there in the moment, and in the moment, what did he genuinely know? And he's going off of the word of someone that he has himself admitted, is very overdramatic and is very, he's a big personality, and he's very charismatic.
That it would be good for him to have a break from him. To get away from him.
Exactly. Yeah. So you self-admitted that he's over dramatic and things like that. And so just because you found one little thing that he identifies with him, we're going to act on this in such a huge and devastating way.
Yeah. I do not know if this is true, but it was just a thought that flitted through my head that I thought, I wonder if Zach would have even considered this had it not been presented to him as the only solution. How much influence did that
would this have been? Right.
He lawyered up immediately. We don't have, an interrogation where he's finally like, look, okay, you guys are putting the screws to me here. I need a lawyer. We don't have that. Everything we have from Zach is post discussion with a legal team. That generally helps. It's great. That's what we tell everyone to do. Shut up. Don't talk to the police. That's sort of like the mantra that we chant over here. And he did that, and I think that is helping him a great deal. But
I don't know. It's just frightening.
Yes.
So my husband retires. We're talking about retiring down in South Carolina.
Maybe not.
North Carolina is great. We're just across the border.
Maybe not Greenville. So, maybe not Greenville. All right.
All right. Thank you so much for the call. Appreciate it.
Yeah, no worries. Have a great night.
You too.
All right. We'll see you.
Bye.
Bye.
She doesn't love you.
Oh, no. Don't point it out like that, 'cause now it really stings. I wouldn't have noticed. All right. Silver Fox not gonna grace Kathy's question with an answer. His hair did not speak to me at all. So, he threw his friend under the bus. That was very, very interesting. I just missed another call. I'm sorry.
So here's the thing, guys, and I know I make references to classic books all the time, but it's my life. This very much reminds me of Pride and Prejudice.
This is Stevie.
Hey, Stevie. Can I bore you with some classics?
Send a voicemail.
Yeah.
Hey, Stevie, hold on for a minute while my wife finishes her thought about classics.
I talk about Pride and Prejudice. Okay, in that book, I'm sure most of you are familiar with the storyline. Elizabeth hears this story from a nefarious guy, and she accepts it, right? She takes it hook, line, and sinker, and she's like, that's absolutely true. And everything she witnesses, she's like, yep. And then after she finds out that he's a liar, she looks back at all the evidence, and she's like, why didn't I see that? Why didn't I see that his words and his actions were not in accord with each other? That he said he would never talk bad about the family. And here he is talking bad about the family to everybody in the neighborhood. And so she didn't see those inconsistencies. That's kind of how it feels here, that it's like he says something, but if you really look at his actions, he's like, I will protect women and children, except right now. And, I don't want to hurt their family. I don't want to get the dad in trouble at all. Oh, you did.
Yeah. Just threw him under the bus. Yeah. Got him arrested. Yep. That does, what does that do for the daughter?
You've never read Pride and Prejudice? Gaily May is on movies.
So, Stevie, go ahead and tell us a little bit. What's on your mind right now?
Hello, Bubbles. I have so much to say, and I'm going to keep it really short because I don't want to ruin the streak of amazing callers that you've had. I want to say that people are far more complicated than in novels. That
felt pointed.
No, but you know what? I love you I love you, Mrs. R.A. Like, I agree with you all
She loves
of the
you.
time.
Thank you.
I love you all of the time. I want to say that I really appreciate you are you're contemplative, and you consider, and you try to look at things from all angles, and you have you are ethical, and you are moral.
And quite often I'm confused.
Look at the look on his face. Look at his face.
I know, I am. I'm like,
his
what's
whole
happening?
mouth just blew open. I don't know.
We have a third question.
Man, they're
I
hustling.
don't know yet. I'm hearing there's a third question.
And they're not going to let us.
Let's see. Let's see if this comes back. So who said we have a third question? Waffles and True Crime. Third question. Third question. Yeah. Jury has another question.
They're moving. They're hauling.
Oh, man.
Sorry, I took up your time with my Pride and Prejudice stuff. What did you want to say?
No. I do we know what the third question is?
Not yet. We're gonna.
Are we
I think
feedback?
we're on live now. I think the feed is happening in real time, and we're not getting the delay anymore. So I'm seeing a little motion in the court. We're seeing.
All right. Well, I see a head.
Yeah. So
we've
got audio turned on. As soon as we hear audio, we're going to bring it in, so you can talk until then.
Oh, please. All right. I'm going to say a couple of things. That people are complicated, and then as we are growing up, we begin to develop an ego, and we really don't do that until we're about 6. And for males, I think it's older. Like
I'm
35.
still working on it.
No, I know. But the point is that I think that he grew up in a very rigid household, and a highly religious household where there were rules. There's the yes and there's the no, and there's right and wrong, and there's nothing in between. Yeah. And I believe him when he talks about his experience with his sister. By the way, there really are emotional vampires.
There you go.
They're real.
I feel vindicated.
They're real.
If nothing else happens right today, I can go to bed feeling vindicated.
I can't believe you've never heard that phrase.
Stevie, thank you very much.
Your whole life.
Yeah, I appreciate it.
I can't believe you lived your whole life and never heard the phrase emotional vampire.
I don't think I have ever heard that before.
Well, now we know, and they're real.
You guys are living I want to live your life.
We're so sheltered. We're in our little Las Vegas
I'm in
room.
my little cubby here with the
I'm
piped-in
from
oxygen.
Philadelphia, New Jersey. We have a lot of emotional vampires. But people don't start to develop that kind of complex personality until they're older. And he was exposed to children who, the parents were like, oh, we're going to adopt some children and bring them over here, like never thinking that these children were really, like, why are they up for adoption? Yeah. They've been abandoned and abused, and love isn't going to fix everything. I want to always believe that it will. But anyway, so he's exposed to his sister. It leaves an indelible mark on his heart. It stunts his growth. Yes, he's a savant, and yes, he's definitely neurospicy, right? And I think that he still to this day, because he's young, right? Is still struggling. Yeah, he's still struggling with the idea of, like, if I tell the truth that this happened and I explain that I did this for Mello and the daughter, really for the daughter, and the whole idea was to make sure that Mello gets to raise her, but I sit here in this chair and I tell the truth, then Mello will go away. Because after all, Mello, attempted to hire me, but at least he elicited my help in murdering the mother of the child. And I have a feeling he probably has a little bit of a dilemma going on in his heart, because that is a moral dilemma. How do I help the girl and not harm the family unit that I hope to turn him to? No?
No, the no was on the question on the screen. How are your kids so quiet? Are they tied up somewhere? There's one of them right there. So. But no, I hear you. I hear you.
Do you see what I'm saying? And so somebody had said, maybe it was you, last night, had said that, in terms of the way that Zachary's doing in prison or jail, he's in jail right now, he's doing really well.
He's thriving.
He's very
Fitz News
peaceful.
announced that he was thriving in the...
Because he knows how to
that
keep
he
the
is
rules.
peaceful. And I think that at some point he's probably going to suddenly kind of get struck by the extreme response he had to his desire, in response to his desire to save a little girl. and that you said it, Mrs. R.A., just before he picked my call up, which is, he overly simplified the solution. John Mello told him this is the only way to solve this problem. And it just became...
he got fixated on that idea. Yeah.
Do I think he really needs some mental health assistance? Yeah, I do. I think he needs mental health assistance because at some point the reality of what he's done is going to smack in between the eyes, and that's going to be really hard for him too.
I hope it does. If it doesn't, then he'll just repeat, right?
Right. Yeah. Right.
Stevie, we're about to. Sorry. Oh, go ahead.
Just one more question. Can you tell me if they gave him lesser included?
We know there are lesser included on some of the other charges, but I didn't think there were on the main charge. It's only 2
Yeah,
page.
I didn't hear it. Yeah.
So I think there's first or second degree on the harassment, first and second degree.
Right.
Yes. So on conspiracy.
I have a feeling they're really going to be struggling over that first degree murder, man.
I think they are.
Uh-oh.
I think they've.
He needs
to
go away.
Let me tell you why.
He needs to not be free.
Why? They have a third question. Okay, the first question was
that?
define malice. Is malice? Do we need to find malice to convict for murder? That was their first question, which the defense loved. Right. The defense was very excited about that question. Yeah. Number 2 was, what's the difference between first and second degree harassment? And those were read out. And now they're saying, what's the difference between first and second degree conspiracy to commit harassment, which is like at the bottom of the bottom of the jury form.
Left.
They're on the last of the list.
They've given one piece of paper and they're doing it.
In the checkout stand, and they're just finalizing everything, and then we have a verdict. So.
Wow.
Nobody has red string on the wall. Nobody's got push pins.
No.
Nobody's suffering over this decision. Oh, it's going to be really interesting what they come up with. I feel I could not believe how moved I was by his story because I am a complex person, and I was watching a person sitting in a chair having accomplished so much, but people are complex. He's accomplished so much, but there are ways in which he's entirely too immature.
Yeah. My issue is that I think he's old enough and capable enough to be accountable for actions. And
I'm not suggesting for a minute that we shouldn't hold him accountable.
Yeah.
Sometimes it's the only way people get accountable.
Yeah.
But in terms of just watching him process how to sit and how to answer. Yeah. I've had clients like him, and that was familiar. Anyway,
Stevie, thank you so much for the call.
Stevie.
It's always great.
I love you both.
Thank you. I'm still in the lead.
Yeah, bye.
Stevie, thank you so much. Bye.
See ya.
All right, great calls. I apologize.
Amazing
if you want to call in, the best thing to do is make sure you are up to the second on the live stream, like as current as you possibly can be, and then wait until a call ends or it's wrapping up and then
Susie.
Call. Hey, Susie, this is Scott. Can you hold on for just 1 second?
Absolutely.
All right. So I was just saying, wait until I'm like wrapping up a call. That's the best time to call. Any calls that come in the middle of a call, I just hit the red X over and over. So it doesn't beep in the background. So that's a confession on my part. I hang up on everybody. Is it Susie?
It sure is. It's Susie from San Francisco, although I don't live there anymore.
Susie's from SF. How are you doing?
Yeah, I'm good. Mrs. already mentioned Pride and Prejudice, and I ran to grab the burner phone number and knew I had to call in and have a chat.
You grabbed that and you grabbed your leather-bound signed copy.
I did the annotated copy with, signed by date. No. But I thought that theory was really interesting about Elizabeth and Mr. Wickham because.
Oh, see, I didn't even say their names and you got it. Good job.
I'm obsessed too. No, but because she is a smart person, obviously.
Yeah.
She's someone who's very astute and she can read into things, and even she was fooled by Mr. Wickham. And
right.
It did take her some time to, once she finally saw it, she saw it. But yeah.
Right.
Anyways. Yeah.
That is great. I'm glad there's another person out there who likes the series as much as my wife does.
I'm going to point out something. I never liked that series until I met Scott, and Scott sat down and watched the movie, and he got it because he understood all their accents, and he understood what they were saying. And I was like, what is happening here? I didn't get the plot. I thought everybody was just like Mrs. Bennett. I did not understand it at all. And then watching Scott watch it is what made me say, wait a second, something else is going on here.
Understanding the accent and the English humor and things like that helped a lot.
Yeah.
Spending some time over in England was definitely good that way.
Yeah.
Thank you. For sure. I need the subtitles for sure. So.
Yeah. Thank you so much for the call. Appreciate it.
Love you guys.
Yep. We'll see you.
Both of us. I'm just saying.
Bye.
Call from Script Goddess.
Hello, Script Goddess. This is R.A. and Mrs. R.A. How are you doing?
I'm very well. I'm one of the other long-time watcher, first-time caller.
Hang on.
People.
Script Goddess, I'm gonna mute you for a second. Yeah. The court is back. We're gonna watch this. I'll bring it back. I'll bring you back on as soon as the question's over.
Madam Foreperson, I've received your question concerning conspiracy and as it pertains to first and second harassment. Conspiracy. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be a guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the persons hold a meeting and expressly state the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. That's the charge on conspiracy, and I would ask you to go back and then look at the verdict form for your direction. Thank you.
And with that, as they leave, we lose the audio. We're going to go back to...
You can go back, and if you have another question, I'm sorry, I just need to abide by procedure, okay? All right.
The higher one, correct?
There's going to be a follow-up. All right, let's see. Script Goddess is on the phone right now.
Hi there.
Well, thanks for holding, first of all. Thanks for your patience. Yeah. What are your thoughts?
Oh, no problem at all. Well, I'm your resident Canadian, by the way.
Yay, welcome.
The true north.
I wanted to, absolutely. I wanted to let you know the one thing that I am getting hung up on is the malice portion of this. And I was curious about this strategy, holding on to the opening statements for defense. Mm-hmm. And that hindering the prosecution and the state being able to call up experts. Because this, not knowing that Zach was going to testify means that they're left not being able to actually give the information to the jury to help the jury with that malice. Like I'm looking for something else. I think what he did was horrible, but that malice is getting me because he was so convincing on the stand.
This is part of the burden the state has. The state is required to share all the evidence they're going to present, as well as any evidence that may be exculpatory, and give it to the defense. Okay, they have to turn that over in discovery, and so defense gets the advantage as far as preparing for that, and not so much on the reverse side saying, well, we're going to say this, although some courts do require you to file notice ahead of time for certain, like if it's a self-defense claim, which this almost was. Yeah.
Yeah, because the thing is, if it becomes self-defense, then the burden falls onto the defense. I did it again, onto the defense. Then
briefly, but only to the level where you assert the self-defense and present some evidence to support that. And then it reverts right back to the state to prove that it was not self-defense.
Okay.
Because in asserting self-defense, you're basically admitting you did it, but it was a permissible reason.
Because the hesitations in my brain, the hesitations that Zach verbalized that he was having, given the chance, the state could have brought up an expert saying those hesitations were actually him overriding the malice in his brain, or like connecting those dots for the jury that he was praying. He was trying to get over those sorts of. I feel like they were at a bit of a disadvantage in this court, that they weren't able to give the jury all of the information they might need.
How fascinating. I've never thought of this scenario existing where, are you going to scream?
I'm answering.
Oh, okay.
Chat.
I've never considered this scenario where there is actually a situation where the defense, by not disclosing how they're going to do it, hamstrings the prosecution. That's a new idea.
I'm full of new ideas.
That's why we love you Canadians. It's wonderful. I've got a sound effect to play for that. I think it's this one.
Got a lot of.
No, that's not it. I'll find it.
That is so fascinating, though, that I've never considered that before, that maybe the prosecution was caught off balance and they could have put up a better case, but they didn't have they didn't know what they had to defend against.
Protect myself that time.
That wasn't it either, sorry.
We in Canada hate you. Is that the one you're looking for? Yes. Oh.
This one?
This police.
That's not it.
We need better labeling systems. Sorry, did you have more to share?
But really, that's the only. No, that was the only point that I've sort of been going through in my brain, that I felt kind of sorry for the state, because I know the struggle that I'm having, putting myself in the jury's shoes. So that is it. I appreciate you taking my call.
Absolutely. I think that's a fascinating question.
I found it.
Awesome.
I found it.
Because we here in Canada hate you and hope for bad things for you because we hate you.
There we go. There's Ian Runkle.
Yeah,
thank
I love
you so
Runkle.
much for the call. I appreciate it.
He's so funny.
Thank you.
All right. Bye-bye.
Bye.
Well, we answer this next call. We do have word there's a fourth question.
Blackbird. To accept, press.
Hey, Blackbird, are you there?
I'm here.
All
It's
right.
me.
That was like an evil chuckle.
We're hearing that there's a fourth question, and it's probably a follow-up to the third. So
They're probably just going to be like, can you please just print it? Just print it.
yeah,
Right.
at this point, the justices in South Carolina need to look at it and say, maybe we should actually give him a copy.
What do you
'Cause
think?
It would be quicker. And I can see the
probably.
reasoning for not giving it to them. We don't want to give them anything that would, influence them one way or another because of how it's written. But it's the instructions.
Yeah.
It's like going to IKEA and getting a package of furniture and not getting that paper that tells you how to put it together.
I don't know. I've seen those
Well,
instructions. They're
and-
pretty much useless.
And also, like, I think as a human race, our memories are shifting probably from more long-term to short-term, like just in time kind of information we can look down on our phone at. So
interesting.
either that or see what I was going to say was the smart kids in the class have had the microphone for long enough, and now the class clowns.
Now let the
turn.
rest of us up. Yes.
Exactly.
Pass the mic back.
Blackbird.
And I feel like I've been sitting
Enlighten
here
us
like in
on your wisdom.
I'm like in the back of the room, and I, not only did I not know we had a quiz today, but I haven't really been
I
paying
didn't study
attention.
anymore.
And what is the subject?
This trial is the subject.
Oh, okay. Well, at least you know that. You're good.
What are your
The
thoughts?
only thing I'm going to get right on the test is malice. That could be found somewhere in this chapter.
Mm-hmm.
So,
Anyway, I did want to know what's for dinner.
At our house?
So,
or just in
that's
general?
question one.
Or for them?
I mean, for
Could
y'all.
be for everybody if you made enough. What do you have, Jen?
We have chicken noodle soup and homemade rolls, and I'm like, winning.
I showed you the homemade rolls. I mean, they are gorgeous.
Oh my gosh, do we have
I bet they are.
Instagram filters are jealous of these rolls. I kid you not. They are so delicious.
I bet they're beautiful. I bet they're burning a hole in the back of y'all's mind just sitting there
I
thinking
bet
about
they're
them.
all eaten by the kids.
I bet you cracked into one and you were like,
I showed one on
"Oh."
stream, and they're giant. I
Oh,
mean,
did
they're
you?
shaped like a softball and just buttery, light, fluffy, just perfect.
Okay.
Golden brown.
Okay, but quid pro quo, what's for your dinner?
Oh, beef tostadas.
Ooh.
And the ingredients are all in the microwave, so if anybody wants one, they're just going to have to go help themselves.
All right.
And good luck finding a plate.
Yeah. Bring your own plate.
Yep.
Or
All right,
wash
I'll let
one
you
out of the
guys
sink.
go.
Thank you so much, Blackbird.
Thanks for the giggle.
Yeah.
Yeah.
Bye. I didn't marry my wife because she makes the best rolls in the world.
I couldn't
but it
cook
was a
when we
benefit
met.
that I found out afterwards.
Zero cooking skills when we first met.
Yeah. Let's see. I couldn't cook either.
Yes, but I gained them.
There's that. I still can't cook. All right. We expect that there's another question.
Are we okay? So you know there's another question, but it's not here yet. Is it delayed? What's happening?
It is sort of delayed, a little tiny bit. What happens? We're on the live feed now. We're no longer delayed 30 minutes in court. So, but we only get to see when the jury is in the courtroom. So there's a question brought in. The judge reads it to the lawyers. They discuss it. They decide on an answer. They say, "Okay, bring in the jury." And the whole time we just get to stare at the wall.
Yeah.
So we get to hear the Twitter version of the question, and then we get to see the live answer.
How do you guys feel about that? About being really like the jury in this particular case, excuse me, where we don't see anything that they're not
Call
seeing.
from Miss Violet.
Miss Violet, you get to be the first one to answer Mrs. Aria's question, but you probably didn't get to hear.
No, I'm sure she didn't.
How are you doing, Miss Violet?
No, I put it on mute. When I saw that nobody had called, I thought, you know what? I'm going to call. And
Now's
if I
your
get through,
chance.
great. If I don't, then...
Yep.
So what was the question?
The question
hang
was,
on, hang
how
on.
do you feel about being just like the jury this time where we cannot hear anything that they're not hearing?
Looks like they're going to bring him back out for a question.
I think it's probably the best idea they ever had.
Really?
Yeah.
Miss Violet, I want all the camera. I want all the audio. I want the sidebars, in crystal clear 4K vision and audio, stereo.
It definitely makes it harder for Scott. He's like, lots of time to fill.
Yeah, well, here's the thing. If we allow for all of the evidence to be on this side of the camera and none of the evidence to be in the jury's hands, then we create a situation where we, as in the people watching, have way too much information and way too much ability to just make snap decisions based on what we think we know.
Mm. And I think it probably also creates a conflict between us and the actual jury that we're like, what's the matter with you? Why can't you figure this out? But we know more than they do.
Right. And we're put in a position where we don't have the availability of trusting the jury.
Or we're definitely going to second guess their decision because we know better, right? So it's,
Yeah, as opposed to the rest of my life when I just trust everybody.
no, but in hindsight, it's the jury comes out of this little room where they haven't been able to see. They've had blinders on and the windows were closed, and they make the best decision they can.
Yeah.
And based on that, and we're like, you got it wrong, and you didn't know it. I would feel terrible as a juror to think that I did the very best based on what I was told.
Yeah.
And
that will
everyone else in the world is pointing
Knew
their
more.
finger at me and shaking their head.
Yeah, that's true. Interesting.
Yeah,
But that's not why you called. What's up?
Well, I just had some thoughts about the pianist, who I'm sure has a name, but I'm not going to give it to him because... Anyway.
Not a fan. Is that what I'm sensing?
Well, it's not that I'm not a fan. It's that I see him, and I'm going to tell you why.
Okay.
In my past life, I was a biochemical engineer.
Wow.
My GPA was 4.0 across the board.
Okay. You're not
You've
saying
already
you
lost
see
me
him.
because I cannot relate.
You're saying you are him. I mean, obviously you didn't kill anybody, but you're saying...
My brain Well, once upon a time, my brain functioned very, 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 very well. Now I'm old and broken, and not so much with the very, very, very well. However,
I feel that.
You've probably forgotten more than I ever knew.
Right.
Continue.
So here's the thing. He is very still. Did you notice that he doesn't move? He's very still.
Yes.
Okay, that's pretty common in people who are at what could be genius level. He's in a situation where he has strived and tackled and gotten everything he reached for.
Mm-hmm.
Why?
So in his mind, he is better than just about everybody else on some level.
I see that same behavior in Brian Koberger in Idaho.
Yes.
But he's not as smart. Oh, you mean you're saying that he's holding still a lot?
Yeah, the same
perfect,
rigid,
very still.
No emotion, very controlled.
Yes, very, very measured. So there's like a juxtaposition between his upbringing, which was admittedly had imposed limits, for lack of a better descriptor, and then add that to the functionality of his brain, and that's how he got to the point where he believes what he did was absolutely the correct thing, no matter what he was taught was wrong. The combination of the two, that middle ground that he found somehow, is how he got to the point where he realized that this is the only way and this is the right way. No matter what comes after, this is the way.
Obviously, it's not a crime to be in control of your emotions that way and be able to present that. And there are many people who have that same effect that do not commit murder, right? So we're not saying that pre-crime you can just arrest everybody who holds very still and doesn't show emotion, right?
Right, but in his brain functionality, it wouldn't be that he was going to commit murder. It was that he needed to reach for this thing, save a child. Whatever the case, the situation is, he was reaching for this one thing, and that's what he got. He didn't fail.
So help me understand why he holds still physically. What is it about having high intellectual capacity that makes your body then hold still?
It's control. We learn from a very, very young age several things. If you're female, you learn about protectionism and all of the things. If you're male, you learn about getting the thing that you want to get. As a male, in his life, he would have had to control himself because he would have been belittled and berated in common society. And so he wouldn't have been able to react, which is where the control comes from. I only know this because as a child, I was the weird kid. And
sure. And I think a lot of us fall in that category. So then I'm having a hard time connecting that. What is it about thinking so much that creates that need to control? Because you can't control your mind, because you can't control your environment. Why have such a tight control over the physical manifestation of motion and energy? Why is that directly connected to thinking?
I'm sorry, go back. I missed that. My brain was looking at chat.
Sorry. I don't understand why being highly intellectual and just being brilliant would force somebody to have more physical control over their body movements. That seems like not necessarily one equals the other all the time.
Right. It's not constant. It's not a consistent thing with every person who has a larger than average brain, for lack of a better descriptor, or has the same upbringing he has. It's specific to the human, but I recognize myself in him in that when I was in school, middle school, high school, college, one of the biggest things I noticed was that because I did very well, there was expectation. I had to be a certain way.
Yeah, that's true.
So it all, once you deal with that for so many years, it becomes a built-in thing. In my adult life, this is probably going to be on the TMI scale, but when my daughter
we've got to wrap up soon, so hurry. I need you to wrap you up just quickly. We've got some more news.
Okay. When my daughter passed,
Oh, I'm sorry.
I was told that I thought you would be more upset.
Wow.
What
that
they're
is harsh.
saying is, I thought that you would display more upset.
Yeah, you didn't grieve the way I would have, so you're not grieving properly.
But that's an
Right,
amazing
he doesn't
insight.
Wow.
And he doesn't move the way we want him to. So
Right.
All right.
Yeah. Anyway.
Thank you so much for the call. I
Thank
appreciate
you.
it. All right.
All right.
Catch you later.
See ya.
Bye. Hey, Mrs. R.A.
Yes, sir. Whoa!
We have a verdict.
And no more ear hearing. It's coming in not guilty.
With 2 hours and 42 minutes of deliberation, the jury has returned a note to the courtroom saying we have a verdict in the case of South Carolina versus Zachary Hughes. Zachary Hughes is charged with murdering a woman he had never met before, but was so against what she did or what she was accused of doing that he knew he had to eliminate her. He said he did it to help save a child. The jury has deliberated. They've heard all the evidence. They've heard just amazing story of a wicked, twisted web. And they, in one day, in under 3 hours, they come back and said, we've been able to make sense of this. We've compared the law. We've compared the evidence. And now all 12 of us are on the same page. We expect momentarily from now the judge to return to the courtroom, the jury to be brought in. We'll be watching live as that verdict is read. And I am on the edge of my seat. I think we filled out 6 bingo cards on this trial. The only score we did not get was Walmart. Everything else that you could possibly believe, and so many things that you couldn't have been included in this trial, from not just burner phones, but from cloned phones, from airport proposals, international custody battles, senators and rushed passports, and allegations of the worst crimes imaginable within a child's home perpetrated by her own parent. Everything has been wrapped into one. We've got a defendant who has already been sentenced to 6 months to serve in jail for contempt within this trial. And now he hears a verdict. He'll hear a verdict. Thank you all for being here. We're not going to interrupt the podcast. We've got 2 hours to the podcast, which is unbelievable. Mrs. R.A., you've never been here for verdict music before.
Yeah, I have. But okay. I gotta say, you were really good at that. That quick summary of the whole thing, hyped up with like, buy a car today music, and you're really good at that.
Thank you. Do you love me too?
I love you too.
I love you as well. A lot of people are saying too fast for not guilty. Too fast for not guilty.
You think it doesn't it usually quicker is not guilty? I thought that's what it was.
I think usually quick is guilty.
But no, because O.J. Simpson was like, bam, and it was not guilty.
That one threw us for a loop as well. But wow. Oh, my goodness. The music, for those that wonder and are new here for the first time, we do the music every time we have a verdict. A little bit because most of the people who watch this channel watch in the background as they're working, as they're at home. They might have us on the TV in the front room. And many people have said, please, can you let me know if there's a verdict? And as much as I'd like to call each and every one of you and talk to you briefly on the phone and say, hey, quick, watch. This is the best way I can do it. It also sort of wraps up all the feelings and sort of puts a bookend on it as we sort of wrap up our deliberation and then turn it over to the jury to hear what their deliberation resulted in. So
which
thank
way
you.
are you leaning? What do you, not which way? I know which way you lean.
I know where I am.
But which way do you think the jury went?
I would not lose a single moment of sleep if this came back as guilty as charged across the board. But with the more I hear about this jury and the more I hear about the ideas, hey, hang on. Amber, you there?
I'm here.
Are you correcting me on something?
No.
Okay. All right.
Finish your thought.
The more I hear that you know, we know that somebody who's charged with a crime has the right to be tried by a jury of their peers, and their peers are somebody who's local, who thinks like them, who understands the norms of the culture in that area. And the more I know that about that, the more I realize I don't know that culture. I don't understand it exactly the way they do, and really I can't project and say, well, clearly the jury, you know, it's a done deal. The jury's got, you know, this one's, you know, just check the boxes. Really, I have no clue. But go ahead. What's your thoughts, Amber?
Actually, it's only because I muted myself.
We've got sound from court.
Before the jury gets in here and the verdict's read, I say this in every trial, that there are a lot of emotions. And I would just ask right now, if you cannot control your emotions, I'm going to give you an opportunity to leave. Otherwise, you're more than welcome to stay. But I just, for everybody involved, please control your emotions, okay? If anybody needs to leave, they can. All right, bring the jury.
Jury's coming in right now. Bailiffs are positioned around Zach. Debbie Smith, welcome to the gallery. Thank you very much. Kathy Lynn as well. Welcome to the gallery. Love that blue courthouse by your name. Appreciate your support. Oh my goodness. Oh my goodness. This is a tense moment. I have no idea. I have no idea what the jury's going to do. They went through these charges so quickly that you know, the questions they had. What do we need to find malice to convict for murder? Is malice a requirement? Or if there's no malice, the reverse would be there. If there's no malice, can we convict for murder? Families present, not as many as before. A bunch of openings on the side where family is usually. There's family and friends right there. Okay. This was so quick. I imagine a lot of people who would want to be in the courtroom are not there right now. The judge is allowing us to get this live as it happens. Bailiff's blocking the view. Zach's behind him, so we focus on the bailiff, who looks content.
Madam Foreperson, I understand that you have a verdict.
What part of we have?
If you can please hand it to the bailiff. Madam Clerk, get your case published.
Your Honor, these are case numbers 2024 GS 23 2194, 5425A, 5413, 5412. As to the charge of murder, we, the jury, find the defendant guilty. As to the charge of possession of a weapon during the commission of a violent crime, we, the jury, find the defendant guilty. As to the charge of burglary first degree, we, the jury, find the defendant guilty. As to the charge of harassment first degree, we, the jury, find the defendant not guilty. As to the charge of harassment second degree, we, the jury, find the defendant guilty. As to the charge of conspiracy to commit harassment first degree, we, the jury, find the defendant not guilty. As to the charge of conspiracy to commit harassment second degree, we, the jury, find the defendant guilty. Signed by our foreperson. Ladies and gentlemen, if this is a verdict you reached in your deliberation room and this is still your verdict now, please raise your right hand. Thank you.
Anything from the state?
Nothing from the state. Nothing as relates to the jury, Your Honor.
Okay. Ladies and gentlemen, I've told you this before, and on behalf of the state of South Carolina and Greenville County, I want to thank you for all of your service for the last 2 weeks. I know this has demanded a lot from you. You all have been extremely attentive. I know that this has not been easy. I'm going to ask you now if you will go back to the jury room, and I will be back there in just a moment to talk to you, okay?
Yes, sir.
Okay. Thank you.
Your Honor, at this time, I would just make a request that sentencing be heard to give defense counsel more of an opportunity to present mitigation.
State.
Your Honor, we would oppose that request and would ask that you would pursue sentencing as soon as possible.
I'm going to give 15 minutes. Fill out them kind of sentencing sheets. Do you feel like you need a little bit more? But I'm going to sentence them within the next 30 minutes.
Thank you, Your Honor. The other thing I would, on behalf of the city, for reasons related specifically that the state did not produce sufficient evidence on each and every one of the elements of the offenses for which the jury convicted or on which the jury convicted Mr. Hughes, for that reason, we're committed for a trial.
Okay. And your motion is denied. You're protected on the record. The only other thing that I need to do is just, and I had discussed this with counsel, as far as the verdict form up at the top, it just needs to be amended to read 2022 GS 23002194, and then it will be 2024 5425A, 2024 5413, and 2024 5412. I just wanted to make sure that that was on the record. It was just more of a typographical, the 4 instead of the 2.
Yes, sir.
Okay.
Yes, sir. We have no objection. No objection.
Yeah. What? And I'll just write on here. Thank you. All right. We'll be back in 30 minutes, 15 minutes.
15 minutes we got.
Okay. All right.
All right. As the judge, that was really noisy. The clerk's mic was on the entire time. What? You need that off? Sorry. Families obviously devastated there. Supporters not happy. Well, the judge said he's going to sentence him within 15 minutes. Defense wants to sentence him in 15 minutes. He's going to be sentenced for this crime, and he says I'll do it within the next 15 to 30 minutes. So a very short break, and the judge will hand down the sentence in this one. I'm just. Is that his brother with the mustache? Is that a brother? Mrs. R.A. Wow, the jury did not disappoint me. They were very quick, but the way the sentence came down, they found him guilty of I would say the more major crimes, the murder and the burglary, and then went with lesser includeds on the harassment and the conspiracy to commit harassment. Which is interesting. Maximum is life in prison without parole. That's on the first charge alone, with that added qualifier. I think I didn't hear it read, but wasn't the jury supposed to rule that on whether or not he committed the crime in possession of a weapon, for the modifier? I thought that was supposed to be in there.
Did the defense say they want a sentence right now, or was that the judge's call?
I think the defense or the state said they wanted sentencing right now. The defense wanted it to be delayed.
Yeah, I would want a cool-off period. This judge is not happy with him. I would be like, let's all go home. Relax a little.
I see life with parole, says Jenny G.A. Do you think the judge will allow the sister to speak? I don't know if there's going to be victim impact statements here. It's a very little lead time. I mean, you need to have your speech ready if he does. That's not much time to prepare your words.
Is this his family that we're looking at?
You're
not looking
You're
at
not. I took him off the screen. That is his supporters. That's his side. That's directly behind his table. Friends and family there. They found guilty with a weapon. Okay, so that was in the first charge. Okay. So that is the modifier that would allow it to be life without parole, I believe. That's not right. The state said they wanted to give defense as much time as they needed, and defense said they wanted it now.
Ooh.
Normally,
I don't think that's a good
they'll
idea.
ask for a pre-sentence investigation or something. No sentencing report. Oh my goodness. Jana, I can't fix the sound. I just can't do it live. I have to do it in post. So I could fix all this and put it together and take the paper rustling out and all that, and we can work on that. But I just can't do it live. I can only take out some things live. Noise like that I have to do on a slower process. Doodles, will we cover the appeal? The defense did preserve for the appeal. They said, Your Honor, this was the quiet part where we could barely hear. They said we'd file a motion because we believe, or we move you to throw this out and give us a new trial because we believe the state did not present enough evidence for the jury to reach this conclusion. And the judge, without taking a breath, basically denied it and said, "What you can, you did your duty. Yes, you preserved it for the appeal, but it's denied." And so his next shot at freedom is going to be the appeal. The appeals process is slow. First of all, it usually doesn't happen, although they'll file notice for appeal usually within 30, 60, 90 days, depending on the rule of the state. The actual appeal might not be for a year or two, as they wait for a transcript from the entire court proceeding, which takes a lot of time, usually 6 months or so for a case this long. And appellate, those appeals are rarely heard. Maybe 1 in 10 might get, reviewed, and even fewer are going to be granted. Let's see. Defense wanted time. I have to go back and hear the voices, and it was really noisy. I couldn't tell which side was saying what. I thought the defense wanted time, and the state said we want immediate sentencing. Oh my goodness. The nerves on this one. It's crazy. I might need a couple extra of your delicious rolls tonight
to help with nerves.
To help me calm down.
I don't know why it is, but this part just always makes me so sad.
Because there are no winners. His family has lost out.
Yeah.
The child who he says he acted to protect has now, through this, and obviously, arguably, it's not his fault, but has lost both a mother and a father. The not his part would be the father side of that.
I don't know if I'm super sad about that part, but I do feel sad at just how many lives have been negatively impacted by this.
Yeah, and I wonder what change needs to happen. First of all, I think South Carolina needs to give the jury the instructions. Oh my goodness!
Yeah, and
give
let
them
them
the
take
instructions.
Notes.
Notes. I'm fine with. Judge can say one way or the other on that, and I see the legitimacy of the argument to say, jury, I don't want you distracted by your notes. I want you focused on the witnesses. Unless it's a long trial. If you know it's going to be 6 weeks long, you better get them a couple steno pads because they're going to need it. Defense said a little time. State said now. Judge said both sides can have 15 minutes to present, but that won't change his sentence.
Whoa. He said that won't change my sentence?
I didn't hear it quite like that. It was. I'd have to go back. Well, I can, because I have the replay machine. Let's jump to the end.
It's just sad. I have the sads.
Yeah. Let's go right here. Let's bring this in on 2.
No, I think you should bring it on 3.
I'll do 3 then. It was on 3. How did you know?
I'm not cool.
This is a replay of what just went down.
Madam Foreperson, I understand that you have a verdict.
What do we have?
If you can please stand to the bail.
I'm going to have to watch the court TV replay on this. Court TV is the pool photographer in this trial. They do have 2 cameras, and they record both cameras. We only get to see one on the pool feed. But I believe they'll have on the verdict, you'll be able to see his face as the verdict is read, as well as the court clerk reading it.
Madam Clerk, could you please post?
Your Honor, these are case numbers 2024 GS 23 2194, 5425A, 5413, 5412. As to the charge of murder, we, the jury, find the defendant guilty. As to the charge of possession of a weapon during the commission of a violent crime, we, the jury, find the defendant guilty. As to the charge of burglary first degree, we, the jury, find the defendant guilty.
The aggravators there.
As to the charge of harassment first degree, we, the jury, find the defendant not guilty. As to the charge of harassment second degree, we, the jury, find the defendant guilty. As to the charge of conspiracy to commit harassment first degree, we, the jury, find the defendant not guilty. As to the charge of conspiracy to commit harassment second degree, we, the jury, find the defendant guilty. Signed by our foreperson. Ladies and gentlemen, if this is a verdict you reached in your deliberation room and this is still your verdict now, please raise your right hand. Thank you.
Anything from the state?
Now listen here.
Nothing from the state. Nothing as relates to the jury, Your Honor.
Okay, ladies and gentlemen, I've told you this before, and on behalf of the state of South Carolina and Greenville County, I want to thank you for all of your service for the last 2 weeks. I know this has demanded a lot from you. You all have been extremely attentive. I know that this has not been easy. I'm going to ask you now if you will go back to the jury room, and I will be back there in just a moment to talk to you, okay?
I'm going to try to take some of the paper sound off on the top end to hear this part a little bit better. One gulp from Zach, one big swallow as that guilty came in. But other than that, a stone reaction.
Your Honor, at this time, I would just make a request that something be heard to give defense counsel more of an opportunity to present mitigation.
Defense wants more time.
State.
Your Honor, we would oppose that request and would ask that you would proceed to sentencing.
State says proceed to sentencing.
I'm going to give 15 minutes. Fill out the copy of the sentencing sheets. Do you feel like you need a little bit more? But I'm going to sentence him within the next 30 minutes.
Thank you, Your Honor.
So he says, I'm going to give 15 minutes to fill out the sentencing sheets. I'm going to sentence him within the next 30 minutes. Do you feel like you need any more?
The other thing I would, on behalf of the jury, for reasons that we would see that that the state did not produce sufficient evidence on each and every one of the elements of the offenses for which the jury convicted or on which the jury convicted.
So he says, I'm going to move for a new trial because the state did not produce convincing evidence on each of the elements for the charges on which he's been convicted.
Okay.
We move for a
And
new
your
trial.
motion is denied. You're
Motion
protected
denied.
on the record. The only other thing that I need to do is just, and I had discussed this with counsel, as far as the verdict form up at the top, it just needs to be amended to read 2022 GS 23002194, and then it will be 2024 5425A, 2024 5413.
So that's the end of that sentencing for what we need. The fun little fact here, which is just crazy. Tonight, Mr. Hughes, Mr. Mello, and Mr. Post are going to be sleeping in the same building. They're all in the same jail, which is just wild to think about. It could be an interesting dinner tonight. Could be interesting times there in the jail. That is wild. But yeah, let's see. We've got just a couple minutes. We're going to stick with this and hear the sentencing is happening tonight. It sounds like there's not going to be much time for anything else, but while we wait for that to happen, let me take a couple calls if we can squeeze it in here.
Call from JC.
JC, how are you doing today?
Good. How are you?
I'm still a bundle of nerves. I feel like your dogs right now.
Oh, I'm sorry. Sorry about that. I was just a first-time caller. First of all, I've been watching the channel for a while.
Wonderful.
I just wanted to share a little bit of my thoughts. First of all, it's a crazy trial. I love all your facial reactions because they were mimicking mine, probably. But I think the jury got it right. I think that they thought it through, and at the end of the day, we can't take justice into our own hands. It was unfortunate all around, but the law is the law.
Yeah, I agree, but I think there's a next step here, right? This has raised an issue, and we've got a scenario where a child was potentially in danger, and there seems to be no functioning mechanism to provide that safety. And I think we, as citizens, we need to look at this and say, okay, great, murder is bad, but now can we address the elephant in the room? And now,
and that's where we as citizens have to come in and ask for that from our lawmakers. You actually referenced a case. I'm from Laredo, so you referenced the Border Patrol case, and it is kind of like a likely case in that somebody thought that some people were doing something against the law, and he thought it was morally wrong, right? And I get that. Whatever, in this case, I understand whatever the parents were doing. I'm not, obviously, that's wrong and everything, but at the end of the day, there's a process for that to go through. And he admittedly lied multiple times. He lied to Child Protective Services about witnessing whatever he saw. He lied about it. Also, he had the advantage that he says he heard, or the dad told him all of this information, but we don't really know when he knew about the inappropriate behavior because he never spoke to investigators or anything. So that could have come in while he was in jail, and he's deciding to use it to his advantage. Yeah. That's something that
I've seen some people raise the thing. It's like, we have no idea what that evidence is, and thankfully we don't. But we do see from the filings in the case against Mr. Post that they have this evidence, that it does exist. I mean, the police aren't just going to write a full report.
I'm not saying that it didn't exist. I'm saying we don't know when this defendant became aware of that.
All right. Yeah. Well, the police, and I think nobody saw it until after this murder. There was suspicion.
Correct. And so he's saying that he did this in defense of a child, but how do we know that it was for this? Like he was just going on the allegations of abuse, but does even the dad know that there was abuse?
I think that's where
kind of abuse going on.
I think that's where the suspicion came from, where he said something's wrong. there might be more issues, and clearly there's going to be a case with Mr. Mello where you've got to imagine that more of this is going to be pertinent to the case. That's going to be, probative.
Definitely, and I feel also like he felt like he was justified morally, I guess, but at the same time, if he really felt for the child, I mean, it was kind of like sad that he literally just threw the dad under the bus. I mean, if you feel like you did it and you said on the stand that you would take the punishment or that you were fine with that, then why put everyone through a trial and almost try and call the child on the stand to have to go through that? Or, I mean, and not that they were going to bring any of that in, but still, like, that's re-traumatizing
they wanted to.
A child.
They wanted to call her.
Yeah, exactly. And so I feel like that you weren't doing it for the child then. You were doing it for other reasons unknown to us. And at the end of the day, the state doesn't even have to prove motive. They just have to prove that he did it and
that he had malice.
They did. So. Exactly. So to me, the jury got it right. And I mean, everyone that needs to be investigated, that's why the law is there. We can't, like I said, going back to my original point, we can't take the law into our own hands, unfortunately. I mean, well, we live in a society where we need to follow the rules. If not, there'll be chaos. And that's just my 2 cents on that.
I agree. But we might also need to change the rules to make sure that children get the protection they need.
Definitely. I totally agree with that on that point. At the end of the day, I feel for the child because she loses on all counts.
Yeah. I feel that in every case, there are victims who are secondary victims, no matter who wins or who loses, which way the verdict goes. There are victims that didn't ask for this in any way. They didn't ask for the attention. They didn't ask for the stress. They didn't ask for the drama, the cost, the scrutiny, and that part's terrible. I feel for them.
Either way, nobody wins. That's what they all say, right? At the end of every trial. Yep. If we're at a trial like this, a criminal trial, nobody wins. Yeah. The damage has been done, basically.
Yeah, you can't undo it. Thank you so much for the call. I appreciate it.
Thank you. I appreciate it. And I'm continuing the love for you and Mrs. Ari.
Thank you. One more in both categories. I appreciate it.
Bye-bye.
Bye. All right. We're just moments away from both dinner, the podcast, and sentencing. So we're an hour and 20 minutes from the podcast. Dinner has to be in there somewhere. And in the next 5 minutes or so, we're expecting the judge to come back and pronounce sentencing. And there may be some statements there. We might hear from people. How are you feeling on this one? You've been very quiet since the verdict.
It just sad, tired. It's bad. I've already said a bunch of times I think this is the result that needed to happen, but it's just sad.
Yeah. Let's see.
Call from
Master Ayden.
Hey, Master Ayden, you sound like you're in a quieter place right now. How are you doing?
I'm doing great. I wanted to put a final thought on this case. Just in case listeners ever hears this in prison on these words. This case has taught a lesson of a hero's tale. If in his mind he felt like he was doing this for the child and he wanted to be the hero, and this was his motive for everything, well, then the system works because he sacrificed his freedom and his life to save that child. If it had meant not guilty, then this trial would have taught another lesson, which is the system failed both the child and him because the system failed her in her mind and it failed to hold you accountable, as he said, for what he did.
Yeah.
So,
appreciate it, Master Ayden. Yeah.
All right.
I know I'm trying to cut people short just because I know they're going to come back in any moment. And I
that's why I made this short and sweet.
I appreciate it. Thanks for condensing it down. Appreciate your call.
Thank you.
We'll see you. Mi Cazador de Ardiles says, I know that's terrible. I'm sorry about the pronunciation. But you're wanting to maintain your freedoms and rights, would not like CPS interference because a neighbor or person doesn't like the way you raise your children. Imagine that. I agree. And let me take it outside of the children and DCF environment and put it into something that I'm a little more familiar with, which is in the tech world. right? I worked with computers, and there's a balance especially when you're dealing with security in computers. You can say, I want this awesome computer system, and I want to be able to log in from anywhere and do my work. And you're like, great, I can do that, but it's not going to be secure. And they're like, oh, we want it secure. And we tighten up the security. And they're like, why is it so hard to log in now? Why do I have to change my password every 30 days? Why does it have to be 16 characters and no words, no numbers, and not match any of my previous 18 passwords? There's a balance back and forth. And with the law as well, when we grant a government agency authority to rip families apart on an allegation, maybe that's too far. And then at the same time, if we pull that back and then we have a case where a child, where someone's trying to raise the flag and it doesn't meet that level where any action's taken, maybe it needs more. Well,
it seems like we have both of those happening right now. Like they're failing on both sides. How is that even possible?
Yeah, I don't know. I don't have all the answers, just some of them.
I don't know, but this is a soapbox for me, and I'd dearly love to go after them.
Yeah.
When I think of a solution for this particular problem, I rule DCF out. I'm like, gone. They're terrible. They're just, nope, not them.
I'm not as quick. In general, I've not heard good stories about them, but there are times where they've done the right thing and been there and caught something that neighbors and friends didn't. So ideally, I think family and friends, neighborhoods combine and solve this problem, and it would be better than having the government to intervene. The government rarely, I realize Pickles not politics, the government rarely is more effective at doing something than individuals are. So, I mean, the things are better at war, okay? That's they're
true.
Better at fighting and defending. Okay, we're going back to court. We're going back to court here. I think the court clerk's mic is still turned on, which could be terrible.
Counsel approach, please.
All right. The judge has the paperwork for conviction prepared. Trying to read his lips. It's not working. We're proceeding to sentencing. It's happening right here. Looks like the defense is the one who's answering the questions right now, so whatever that was. The state didn't have much to say.
Okay, I'll hear from the state.
Thank you, Your Honor. Please, court. We're prepared for sentencing. That's what we're here for today. You've heard a long 2-week trial. You've heard the actions of the defendant. You've seen the extreme violence in this particular case. Calculated the premeditation. The jury's found him guilty. Your Honor, the state would be requesting a life sentence for the murder and for the burglary first charges. But before you switch over to the defense, I have Tina Parcell here who would like to address the court, which is the sister of Christina Parcell.
Thank you, Ms. Parcell.
Thank you, Your Honor. I will apologize in advance. I didn't expect to actually reach this point today. This is my second victim statement in 24 hours. Yesterday was reliving the 2 worst days of my life. Between hearing the step-by-step account of my sister's murder, Mr. Mello's 2 new charges, his bond hearing, and my niece being put into emergency protective care again. So I am exhausted, and I'm going to do my best to express myself appropriately. So with Your Honor's leniency, just give me a bit of grace. My understanding is this conversation is with you. This isn't with the defendant. This is not with counsel. This is not with the gallery. So this is a conversation with you. And I've had 3 years to try to articulate how this has impacted me, and I still have yet to find the words, and it won't happen tonight either. So I've decided instead to talk about what logically should be taken into consideration for any sentencing, which is remorse, rehabilitation, and recidivism. This defendant sat on that stand with full disregard for the authority of the law when it came to his actions outside of this courtroom, in blatant disregard for the authority of law inside this courtroom. He recounted step by step in excruciating detail everything he did. And if I may paraphrase the defense counsel's closing statement, did he cry? Did he shake? Did he look visibly distressed? He said the word repulsed, but did he once look repulsed? He said the word vomited. Did he ever once look nauseated as he described dragging my sister through my living room? Cold doesn't begin to describe the lack of emotion. And if I may be blunt, if we're going to argue somebody has to have malice and hate in their heart to be capable of murder, then one could also argue that anyone medically diagnosed as antisocial personality disorder is therefore not capable of committing murder. I think that is a logical fallacy, is asinine, and the fact that I'm tired, I will no longer go down that, but there has been no remorse once shown by this defendant in this courtroom. Without remorse, you cannot have rehabilitation. Rehabilitation requires acknowledgement that I have done a wrong, I have a debt to pay, and I can improve to become a better member of society. It begins with remorse. Without remorse, there is no rehabilitation. Without remorse, without rehabilitation, you have recidivism. This man, no, I'm sorry, this defendant wanted to kill someone. He joined the Marines, specifically the infantry. He wanted to kill someone. He was given a target on a silver platter. He was given an address, a date, a time, and he planned it. because he knew that if he planned it just enough, he would never get caught. He planned it so much that he thought, well, even when I got caught, I got this. I can still get out of this. Without remorse, without rehabilitation, any person that goes through that effort to commit a murder would absolutely do it again to see if they could. You're left with either two options. Either he is a weak, easily manipulated man who would kill anybody that anyone asked him to, or he's not a weak and easily manipulated man. And if that's the case, then he absolutely would do this again to see if he's smart enough this time, to see if he can beat it this time, because he has shown no respect for the law of this courtroom. The only thing that I will say about this situation overall is that all of these men did nothing but use my sister. John Mello used her to create a whole new family when he had a wife and children already. Brad Post used her. This defendant used her. All of them used her for their own twisted personal gratification. He would do it again. Without remorse, without rehabilitation, you will have recidivism. Thank you, Your Honor.
Thank you, ma'am. Anybody else from the state? Okay. Defense.
Your Honor, may it please the court, Your Honor's presided over this trial. Your Honor is aware of the evidence that was presented at the trial. Your Honor is also aware of the evidence that was proffered. We do believe that could go to mitigation, so we would ask Your Honor to consider that very carefully. Zach has no prior criminal history, and he stands ready for sentencing. Your Honor, I would ask for Mr. David Hughes, Zach's father, to have the opportunity to address the court briefly.
You stand right there.
Thank you, Your Honor, for the opportunity to speak a few words on my son's behalf. The trial is over. A verdict's been rendered, and we accept that. But what I want to speak to, because I understand this is the sentencing phase of the trial, where you have some parameter of your sentence. My son is probably, in my lifetime, and I've run into some pretty amazing people, and this is going to be seen as a bias from the father, but he has got such a strong moral compass and fortitude and desire for the truth in his life than really anyone I've ever met. He actually eclipses a lot of those things that I aspire to myself.
Hey, chat, please be kind to chat.
It's what makes his music so incredibly meaningful, because as a musician, and there are some world-class musicians sitting here today, colleagues of Zach's, what makes a musician's art come through is what's the essence of who they are. It's not something you can fake. When you hear it, you know it's a fake. When you hear music that causes people in a room to weep, you know it's coming from something inside that person that you cannot describe. Zach was not born with a silver spoon in his mouth. I want to tell you that. I taught all my children, Zach being the oldest, the value of hard work. He might have been the only person at Juilliard to show up without manicured fingernails and calluses instead. He worked hard. I pushed him hard. Fathers and parents tend to do that with their firstborn child. And maybe I pushed him, a little hard at times. But it made him the man he is today. I want to address something, and Mr. Wilkins?
I got to just address the whole thing. I'm sorry.
That Zach is a cold-blooded killer. I am sorry. Zach wrote his mother and I a letter delivered to us through his attorneys approximately a month ago. In that letter, he described basically what he did in that chair over there, only in a little more detail. Why he did what he had to do, what he felt he had to do. You heard him say in that chair, he wasn't going to go on a cruise ship to Bora Bora, where he was headed, and look at himself in the mirror at night after playing beautiful classical music for rich people. He couldn't do that. Zach has been brutally honest in his life. So much, sometimes to the detriment of his own career. Everybody in the piano world wants to be a soloist with an orchestra. But it's a very small amount of room on the head of that pin, and that's where he was headed. But he had people in his life, donors, rich benefactors, who made demands of him artistically in exchange for their financial benefit, and he walked away from it to the detriment of his own career. Why do I bring that up? He has such a strong moral compass and a desire for the truth that sometimes he actually hurts himself. His friends here, all these people in this courtroom for the last 2 weeks have been here day in, day out. Some as far as from Seattle, Washington. They're here because they grew up with Zach in the music world, and they saw something in him they didn't see in anybody else. He has got a loyal circle of friends that I never had. I told my kids when they grew up, if you, at the end of your life, you end up with 2 or 3 people in your hand that are really there for you, that's the guy I want in the foxhole with me. Consider yourself lucky. Zach's got a dozen of those. Why? Bettina, I'm sorry for your loss. I'm not supposed to mention her name. I'm sorry. But I want you to know, Zach had felt compelled to do what he did because of what he would quote Edmund Burke on this. The only thing necessary for evil to prosper is for good men to do nothing. Okay. His desire for the truth and his truthful telling of what happened. I mean, he sat there and he didn't hold anything back that would benefit his portrayal to this court. He's just as brutally honest with himself as he is with other people. He has no criminal record whatsoever before this event. The only thing I know of is an outstanding traffic ticket in Italy somehow he rang up when he was there with Mello. And several of the guards in the detention center, he's been for 3 years, he's been an exemplary inmate, had told him that they were going to come to this trial to support him. When you gain the silent respect of law enforcement officers, they see something in you, they see it all. And they see a guy that's respectful, for 3 years without a single incident, I think that counts for something. So I'm just here, I'll wrap it up. As you determine your sentencing, I would ask you to consider what type of man he is, and take that into consideration. I love my son. I'm proud of my son. Thank you, Your Honor.
Anything else from the state?
No, Your Honor.
Yeah, just for the purpose of the record, I don't. Would Your Honor want to inquire Zach as to whether or not he wishes to speak?
That is up to you. Sorry, I thought that you had indicated that.
He does not wish to speak. I just want to put that on the record.
Okay.
Whoa. Now it's up to the judge, unless they get sort of closing statements. Someone just signed a paper with a big signature.
Zachary David Hughes, indictment 2022 GS 2302194, indictment for murder. You're to be committed to the State Department of Corrections for life. Indictment 2022 GS 2302194. You're to be committed to the South Carolina Department of Corrections for 5 years. That is to run concurrent. Indictment 2024 GS 2305425A for burglary first degree to run concurrent is for you to be committed to the South Carolina Department of Corrections for life. The other two indictments, 2024 GS 2305413 for conspiracy to commit harassment second degree is 30 days time served. Indictment 2024 GS 2305412 harassment second degree, 30 days time served. You're to be dismissed.
Thank you, Your Honor.
He looks back at his supporters and nods. And is taken into custody. He said for life. He said for life. We'll have to look and see in South Carolina what that means. Life in prison. They are concurrent sentences, meaning everything runs at the same time. There's no. It's not going. He doesn't serve one life sentence and then once that one's over, which and then serve another. It's just everything's at the same time. Probably not concurrent to his contempt charge. Sorry, I'll give you your mic back. Sorry about that. Wow. life for murder, life for the burglary, and 30 days each for the two smaller charges. The remarks, I don't know. A parole might be decided solely by the parole board at some later time. Oh, life in South Carolina is no parole. Life in South Carolina is 30 years. We have competing stories. It's parole. It's without parole in South Carolina. Life is life. Remember that from Murdaugh. But to talk about the statements, wow. The sister's statement, very well put, able to address the three issues that I think are very important, when at least the three issues the parole board should definitely consider, but which they won't need to now if he's serving life in prison. But, man.
She was very eloquent. She did a good job articulating the logical steps to... she did a good job articulating the logical requirements of being able to tell if somebody is changing. And she used the word recidivism a lot, which just means going to commit the crime again. And so she was saying, if you don't, if you want to feel confident that this person will not commit the crime again, then they need to show remorse. And I don't remember the second one she said.
Yeah. It was powerful when she used the words of the defense attorney in closing arguments about Zach. He used those descriptions. Did you see this? Did you see, was there any sign? I thought he was talking about, who was he talking about when he said that? Was that about Christina? And was she upset about these pictures being sent? No, there's no evidence that she was upset at all. And then to flip those words back around at him, that was powerful. And to hear that this is her second victim impact statement in 24 hours.
What was this? I didn't understand that. Where else is she going to be giving a victim impact statement?
In the bond hearing for Mr. Mello.
Yesterday.
That was last night, 9 p.m. So 24 hours ago, she was doing this again.
This is tough.
Yeah. Speaking of 24 hours, we have much less than that. Much less than that before we have a podcast tonight. We will do the Not Relevant podcast right here on this channel. It is a live stream much like this, but it's a light break. We've had some heavy days in court. The topics that we've been discussing and the facts as they've been presented are very difficult. They're very heavy. I personally believe it's not good to always dwell in those moments. And so once a week, we have a break where we have a podcast that is more lighthearted, which is fun. We have the same community that you saw here. We'd ask you to join us. And the easiest way to do that is click the subscribe button and ring the bell so you'll be notified when we go live. It'll be 8 p.m. tonight right here on this channel. I'll make the placeholder for that here in just a minute. But do join us. We'll probably talk a little bit more about this tomorrow as it is Friday. Probably not going to jump to a new case tomorrow. So we might do a tiny bit of court hopping and then discuss this a little bit as we sort of get a night to think it over and gather our thoughts on that. Does Mrs. R.A. join the podcast?
Virtually. No.
I have once or twice when Thomas is gone, but yeah. Thomas and Scott have an amazing rapport with each other. They're very good at playing off of each other and having a lot of fun. And you guys get to see a lot of the seriousness. You get to see some of Scott's sense of humor during the week, but it is just much more on display when he's eating nasty food. That's all I'm saying.
I don't have any nasty food for tonight.
You think that.
Good. Carolyn, thank you. I just saw a Venmo come in from you. Thank you. Thank you, Carolyn. That is super generous. All right. With that said, we're going to play this music one more time. I've got to think this one over. I'm not upset at the verdict. I'm not upset. I'm at peace with that, but I think there's more that needs to be done. Tonight when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe until we go live again in 40 minutes. Well, 45 minutes.
Somebody wake Thomas up.
Yes, text Thomas. Let him know the podcast is tonight. Thank you all. Thank you all for being here. A special welcome to everyone who's here for the first time. I hope you do enjoy this community. I found it to be incredible. It's the best place to watch true crime. I've got to say thank you to all of you. You guys are amazing. We will see you tonight at the podcast, and then tomorrow morning we'll be back with more court watching and some court hopping.
Awesome. You guys, what you're doing really, really matters, and you're doing a much better job than you think you are. Keep it up, and we'll see you tomorrow.
Thank you all. We'll see you.
I want to kick back, taking it easy.
Shame on you, sir.
Thank you, sir. You're my new best friend.
Because he's the guy.
Is that correct?
Scratch all that. Oh, that was terrible. I apologize.